I am now calling this meeting of the Indiana Recount Commission to order. I am Indiana Secretary of State Diego Morales, Chairman of the Indiana Recount Commission. With me today are Recount Commissioners Michael Claytor and Commissioner Paul Mooley. I will note for the record that 3 Recount Commissioners constitutes a quorum for the Recount Commission. So with everyone present, we have authority to proceed today. I will also note for the record that notice of today's hearings were posted at the Government Center and on the online Recount Commission webpage. Also, parties to the proceedings were served with notices of today's hearings. As usual, I would like to start the meeting with saying the Pledge of Allegiance. So everyone, please stand with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. With us today is Attorney Evan Norris, our Recount Director, Attorney Matthew Kochiver and Kegan Prentice serving as legal counsel to the Recount Commission. Thank you both. Also, representatives of the Indiana State Board of Accounts, State Examiner Paul Joyce, Chief Auditor Jennifer Calgar, and Board of Accounts General Counsel Matthew Black. Also, Stewart and Richardson, court reporter, is here today. Today's agenda includes receiving the State Board of Accounts recount report for Senate District 23 and deciding on some preliminary motions that have been filed for the recount and contest. Will any candidates on this contest, as well as anyone who may be giving reports today, please stand and be sworn in. Please raise your right hand and respond with "I do" after I finish reading. I do solemnly swear under penalties of perjury that the testimony you may give today is the truth and nothing other than the truth. So help me God.
I do.
Thank you. Please be seated. The recount and contest petition filed by candidate Paula Copenhagen on May 18th, 2026, asked for a recount of the entire district. No cross petitions were filed. With that, we would like to recognize Mr. Norris, a recount director, for a report on the recount procedures, as well as presentation on the State Board of Accounts report. Mr. Norris.
Thank you, Secretary Morales. It's my honor to be here today as the recount director. Again, Evan Norris with the law firm of Drury Simmons Bornham. Accompanying me are attorneys Nick Plopper and Jeff Kraft as well. They serve as deputy directors. Today, the 3 of us will be presenting to you the report of the SBOA and then also providing some preliminary background on a few discovery motions that the parties have filed. At this time, I would ask to approach the table and present you and the parties with the SBOA report. May I proceed?
You may.
Thank you. Oh, proceed from the podium.
Of course. May proceed.
All right, Mr. Secretary, thank you again for the opportunity. Commission, thank you for the opportunity to report to you today on the SBOA's findings in this matter. As the commission is well aware, there are various statutory and procedural guidelines that we must follow per the Recount Commission's guidelines in order to finalize and begin to adjudicate this recount process. And so today we have a very quick hearing roadmap here. We will start with counting all the votes from precincts with no disputed ballots. Then we will review and count or not count all undisputed vote categories in disputed ballot precincts. Then we'll accept and implement any ballot position statements. And we'll place the remaining recount in contest proceedings. It will be my recommendation to put it in abeyance. And then we will have hearing and ruling on pending motions and then other matters and then potential discussion on next hearing dates and the dates associated with that. So with that, moving into phase one. So the commission is well aware that the recount director shall present the report of the votes cast for each candidate in the indicated precincts where there are no disputed ballots in one or more precincts. So if the commission will bear with me, I will go through county by county and then precincts and then ask for specific motions as they may come up as prescribed under the rules. First, I wanted to indicate that the first county that we're dealing with no disputed ballots are those counties highlighted in gray in Fountain County. Those would be Kane 1, Kane 2, Jackson, Logan 3, and Troy 4. Those are the 5 precincts within Fountain County where there are no disputed ballots. At this time, I would recommend that a proposed motion be made to accept those precincts in Fountain County as presented.
I make such motion.
Second.
Is there any discussion? Those in favor?
Aye.
Aye. Those to reject say nay. The ayes have it.
All right, thank you. So we have now accepted the votes within Kane 1, Kane 2, Jackson, Logan 3, and Troy 4 in Fountain County. Next, commissioners, I will present to you the precincts with no disputed ballots in Montgomery County. In this particular county, we only had one precinct, which would be Coal Creek precinct, which was the only county with no disputes, or excuse me, the only precinct with no disputes in it. At this time, I would recommend a motion that with regard to Montgomery County, that the commission move to accept the recount director's report and that the commission count the valid ballots cast for each candidate, it not count any undisputed invalid ballots, and not count any undervotes in Coal Creek precinct.
I so move.
Second.
Do a second. Any discussion? We're gonna vote. Those in favor say aye.
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 Thank you.
The ayes have it.
With next, commissioners, I will take you to the precincts with no disputed ballots in Park County in particular. This is number 3 of our 6 counties. In Park County, you will see that we only had one disputed ballot in the entire county. So therefore, I would recommend that the commission make a motion that with regard to Park County, that they move to accept the recount director's report and count the valid ballots cast for each candidate, not count any undisputed invalid ballots, and not count any undervotes in the following precincts: Adams 2, Adams 3, Adams 4, Florida 1, Florida 2, Howard, Greene, Jackson, Liberty, Penn, Raccoon, Reserve, Sugar Creek, Union, Wabash, and Washington.
I make such a motion.
Second.
Those any discussions? Those in favor say aye. Aye. The ayes have it.
Thank you. Next, we will move on to county number 4, which is Tippecanoe County. As the commission will see, there are several precincts within Tippecanoe that do not have any disputes within them. So I would recommend that the commission make a motion with regard to Tippecanoe County that they accept the recount director's report. They count the valid ballots cast for each candidate. They not count any undisputed invalid ballots, and they not count any undervotes in the following precinct: Jackson 1, Randolph 1, Shelby 1, Union 1, Wayne 1, Wabash 1, 2, 3, 5, 6, 7, 8, 9, 10, 11, 12, 13, 17, 19, 20, 21, 22, 23, 25, and 27.
Do we
I'll
have
make
a-
that motion.
I'll second.
those in favor, any discussions? Those in favor say aye.
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 The ayes have it.
Thank you. Next, we'll move to Vermilion County. In Vermilion County, you will see we only have two disputed ballots in the entire county. Therefore, I propose that with regard to Vermilion County, that the commission make a motion to accept the recount director's report to count the valid ballots cast for each candidate, not count any undisputed invalid ballots, and not count any undervotes in the following precincts: Cayuga, Clinton City 1, 2, 3, and 4, Clinton Township 1, 2, and 3, East Helt, Fairview 1 and 2, Highland, St. Bernice, and Vermilion 1 and 2.
Do we have a motion?
I make such a motion.
Second.
Any discussions? Those in favor say aye.
Aye.
Aye. The ayes have it.
Thank you. And finally, the precincts with no disputed ballots in Warren Township are as follows. I recommend that the commission make a motion that with regard to Warren County, that they accept the recount director's report to count the valid ballots for each candidate, not count any undisputed invalid ballots, and not count any undervotes in the following precincts: Adams, Kent, Mound, Pine 2, Prairie, and Steuben.
Do we have a motion?
I make such a motion.
Second.
Any discussion? Those in favor say aye. Aye.
Aye.
The ayes have it.
Thank you. Now we will move on to phase 2 of the tallying process. In phase 2, we are now supposed to go into the precincts where there are disputes and essentially have the commission pull out those disputed ballots and affirm that the undisputed ballots count towards those individual candidates in those disputed topics. So I will walk through this with you very quickly through each county. So as you can see here, for Fountain County, as presented on the screen, the SBOA report shows that in Davis, Fulton, Logan 1, Logan 2, Mill Creek, Richland 1 and 2, Shawnee, Troy 1, 2, 3, Van Buren 1, 2, and 3, and Wabash, that we have undisputed valid ballots tallied by the SBOA. You also see here that there are no undisputed invalid ballots tallied by the SBOA for Fountain County. You also show that the undervotes in the contested precincts are shown here as well. So again, this is a procedural type motion. Here I would propose that with regard to Fountain County, that the commission move to accept the director's report and find as follows: that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes be counted for each candidate in Fountain County as I just presented, and that the total undisputed undervotes not be counted in Fountain County as I just presented.
So moved.
Second.
Any discussions? If not, we'll vote. All in favor say aye. Aye.
Thank you.
The ayes have it.
We will do the same process for Montgomery County. We are here to show the undisputed ballots tallied by the SBOA. In the reports, you will see here that we have 3 precincts where there were disputes. Those would be Brown, Ripley, and Wayne. In those 3 precincts where there are disputes, you will see that there are no undisputed invalid ballots tallied by the SBOA. And you will also see that there were 22 undervotes cast in Montgomery County, which should be not counted as part of the recount. Therefore, I would propose a motion that with regard to Montgomery County, that the commission move to accept the director's report and find that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes be counted for each candidate in Montgomery County as presented, and that the total undisputed undervotes not be counted in Montgomery County as presented.
I make such a motion.
Second.
Any discussions? Those in favor, say aye. Aye. Any opposed? The ayes have it.
Thank you. We will move to county number 3, which is Park County. Again, we only have one precinct being challenged and one total ballot being challenged in Park County, and that is in Adams 1, which shows a total undisputed valid ballots tallied by the SBOA to be 50 for Copenhagen and 79 for Deary. Here you will see that the undisputed invalid votes for each candidate in Park County is 0 in the counties, in the precincts where there is a dispute. So if we look at Adams 1, we look across, there's 0 there tallied in the undisputed invalid ballots. And then for this part, we also need to discuss the undervotes. And for this particular precinct, the precinct at issue, which is Adams 1, you'll see there are no undervotes cast in the Adams 1 category. So therefore, I would propose that the commission make a motion that with regard to Park County, that they move to accept the director's report and find that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes, which is Adams 1, be counted for each candidate in Park County as presented.
So moved.
Second.
Any discussions? All in favor, say aye. Aye.
Aye.
Any opposed? The ayes have it.
Thank you. All right, moving to Tippecanoe County, you will see here that we have at least 8 or so different precincts where there were disputes, including Shelby 2, Wabash 14, 15, 16, 18, 24, and 26. I will show that there are no undisputed invalid votes in these particular precincts that are at dispute. And lastly, I will show that there are a few undervotes cast in the precinct, 121 undervotes cast in total in Tippecanoe County. Therefore, I would recommend that the commission make a motion with regard to Tippecanoe County to accept the director's report and find that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes be counted for each candidate in Tippecanoe County as presented, and that the total undisputed undervotes not be counted in Tippecanoe County as presented.
Do we have a motion?
I so move.
Second.
Any discussions?
Just a quick question, if Mr. Chairman. I know the answer, but I'll ask it anyway. In Shelby 2, the 6 disputed undervotes are included in the disputed vote tally. Is that correct?
Yes, they are at least at this point considered to be in the disputed vote tally. And I believe that is the subject of section 6 later, which we will get to as well. Yes.
Thank you.
Any other discussions? All in favor, say aye.
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 Any opposed? The ayes have it.
Thank you. Okay, 2 more left. In the undisputed valid votes for each candidate in the contested precincts in Vermillion, there are 2 exhibits or 2 ballots challenged in Dana and Eugene precincts. You will see here that there are no undisputed invalid votes in those 2 precincts. And you will see that there is at least 1 undervote in those 2 disputed precincts. So I would propose that with regard to Vermillion County, that the commission accept the director's report and find that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes be counted for each candidate in Vermillion County as presented, and that the total undisputed undervotes not be counted in Vermillion County as presented.
So
Seconded.
Any discussions? All in favor, say aye.
aye.
Opposed? The ayes have it.
Thank you. And lastly, commissioners, we have the undisputed valid votes for each candidate in Warren Township, in Warren County in the following precincts as shown on the report. I will show that we have no undisputed invalid ballots tallied by the SBOA in this particular precinct, in this county. And I will show that we have 1 undervote in the contested precinct of Dana precinct in Warren County. Therefore, with regard to Warren County, I recommend that the commission move to accept the director's report and find that the total number of undisputed valid ballots tallied by the SBOA in the precincts with disputes be counted for each candidate in Warren County as presented, and that the total undisputed undervotes not be counted in Warren County as presented.
Do we have a motion?
I so move.
Second.
Any discussions? All in favor, say aye.
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 Opposed? The ayes have it.
Thank you. And with that, Commissioners and Secretary, I would like to move into phase 3, which asks for the recount director shall report to the commission whether a statement described by section 6 has been filed with the recount director regarding any disputed ballot. If so, the commission shall proceed to order the ballot to be counted for a specific candidate or not counted in accordance with that statement. Attached, I have the pertinent first page of candidate Copenhaver's statement. And if I could, I would like to approach the commission with the party's statements very
You
quickly.
may.
Thank you. Thank you. Mr. Secretary, before you have the two Section 6 statements that I requested from the parties. On the screen is the first pertinent page of candidate Copenhaver's statement on number 6. You will see here that there are 7 withdrawals filed by candidate Copenhaver, one with regard to SBOA exhibit number 1 and Shelby 2, and the rest pertaining to exhibits 9 through 14 of Shelby 2 as well. And at this time, I will note for the record that candidate Copenhaver's withdrawal of the dispute doesn't necessarily remove that exhibit because it's also been objected to by candidate Deary, or excuse me, Senator Deary. So with this, I think that the commission is well positioned to make a motion to accept candidate Copenhaver's withdrawal of her dispute regarding SBOA exhibit number 1 and Shelby 2 within the county. However, that does not mean that it won't be an exhibit because candidate Deary has still maintained his objection over that disputed ballot.
Do we have a motion?
I make such a motion.
Second.
Those in favor, say aye.
Aye.
Opposed? The ayes have it.
Thank you. We will show then that candidate 1, Copenhaver's objection to SBOA exhibit number 1 has now been withdrawn. Further, I would show that to Commissioner Claytor's question a few minutes ago regarding those 6 undisputed undervotes tallied by the SBOA, that we had 6 that were disputed. Here, candidate Copenhaver has asked to withdraw 6 of those disputed undervotes that were tallied by the SBOA. And so at this time, I would recommend that the commission make a motion to accept candidate Copenhaver's withdrawal in Shelby 2 precinct in Tippecanoe County of the following exhibits, and that they shall be designated as undisputed undervotes in Shelby 2. And those would be SBOA exhibits 9, 10, 11, 12, 13, and 14.
Also move.
Do we have a second?
I do second.
Any discussions? Those in favor, say aye. Aye. Opposed? The ayes have it.
Thank you. That will show that candidate Copenhaver has withdrawn her objection then with regard to exhibits 9, 10, 11, 12, 13, and 14 in Shelby 2 of Tippecanoe County, and that those shall be marked as undisputed under votes tallied by the SBOA. Candidate Deary filed a statement as well, and candidate Deary reserved the right to withdraw challenges at a later time. Senator Deary does not intend to withdraw any at this time, I believe. Correct. And then I guess I would ask the same of candidate Cope. Anything other withdrawals at this time?
No.
Okay. With that being said, Mr. Secretary, I would recommend that the commission at this point, because we have so many discovery motions, that the commission move to hold in abeyance the remainder of the guidelines and the statutory procedures that are required after we have just gone through this process of removing the ballots under number 6 and number 7, and so that we proceed with subsection 8 at a later date by order of the commission.
Also moved.
I second that.
Any discussions? All in favor, say aye.
Aye.
Opposed? The ayes have it.
Thank you. And lastly, I think what everyone here, and there's no action needed on this. I just want to give an update report to the commission. So just to show what the culmination of the SBOA's efforts, obviously led by Examiner Joyce and Deputy Examiner Gouger, the total results that were certified for this election show 6,334 votes for candidate Copenhaver and 6,337 votes for candidate Deary. I am, proud to announce that the SBOA's tally resulted in the same exact vote totals across the board for them. So just to give the SBOA and the county clerks just a little more credit, the SBOA's tally did equate to what the certified statements were that were sent in by the county. So just want to show that there were no discrepancies in the actual tally itself. We're here to talk about the disputes. And with that, we've only been going for 30 minutes. Happy to roll into the next portion of, if the commission would the commission like to proceed into the pending motions?
I don't think there is a need for a break, so we should proceed.
Okay, perfect. All right, then. The first, commissioners, as you know, there are several pending motions before this commission at this time. And I would like to, at least for each of these motions, what I've proposed to the parties is that our group, myself or the deputy directors, will give you a brief introduction into what request or what is being asked for in the motion. And then we'll simply permit the parties 5 minutes each for arguments, 5 minutes for argument, 5 minutes for response, and then 2 minutes for rebuttal if the commission will permit it. We will keep track of time over here. Mr. Plopper will. I presume that some of the parties may ask for additional time at some point. So permit them to, as the commission sees fit. So at this time, I'm going to turn it over to Deputy Director Kraft, who is going to just very briefly lead us into the motion to dismiss.
Sorry, go ahead.
Go ahead, Commissioner.
I'm reading over your shoulder and this is behind me. Do you have a paper copy of this by any chance?
I can get you a paper copy. Yes, one moment. Deputy Director Kraft will lead us in very quickly. If you want to just do it from the table, that's fine too.
Thank you, Mr. Director.
Mr. Norris, we have another
Oh,
question.
yes.
Should we have the commission adopt the
Yes.
position outlined by the recount director of the timeframes, order of presentation, so that we're on record as adopting the procedure?
I so move to adopt the procedure.
I second.
Those in favor to adopt, say aye.
Aye.
Aye. Opposed? Passed.
Thank you. So at this time, we will briefly lead into the candidate Deary's motion to dismiss, then turn it over to Senator Deary for presentation and then response and rebuttal. So thank you.
Thank you, Mr. Director. Good morning, everyone. We are beginning, as Director Norris said, with Senator Deary's motion to dismiss the election contest portion of the verified petition for recount and contest. I'm confident the parties will get into more detail about the arguments contained therein, but in broad strokes, Senator Deary is arguing that the petition was required to meet a certain threshold regarding factual specificity for the basis of the contest claims, and that the petition failed to meet that burden. Senator Deary is requesting that the commission dismiss the election contest portion of the petition with prejudice, deny the request for subpoenas, depositions, and additional discovery related to the contest allegations, restrict the proceeding to any properly pleaded recount issues, grant any other appropriate relief. I will note we are proceeding with this first because this is a threshold issue. I will defer to the commission's learned counsel if they think otherwise. But my understanding is that the commission must rule on this motion to dismiss before it can proceed with the contest portion of the allegations. And with that, unless the commission has any further questions, I will turn it over to Senator Deary to present their arguments.
The council, you may.
Thank you. I'm Samantha DeWester. I represent Senator Spencer Deary. First of all, I want to start by saying thank you to State Board of Accounts, the recount director and his team, and probably 40 different people that were involved between SBOA, the recount team, 6 different county clerks and their staff, the recount commission, their lovely attorneys who were on site with us 6 days in 6 different counties, who gave up time with their families, long days, overnights at some state parks. Okay. But I want to thank you guys for your time. It doesn't go unrecognized how much work it is, and Evan did a fantastic job of picking up quickly and the ground running. I know this is his first time doing this. I've gone through this several times. He's done fantastic work. And I think everyone would agree in just keeping all the trains on the track. So starting off, I want to address my motion to dismiss. Under Indiana code, a contest can be requested by a party, a contestant, a candidate for office, and it specifies under 312.11.3b specifically what grounds a contest can be requested. There's a ballot printing issue, there's a machine issue, there's a mistake in the programming of said machine, or if there is an act or deliberate acts that have occurred in stating all 4 of these things, the General Assembly has set out that the petitioner must, there isn't an option, must identify with specificity the precincts of which they are challenging and what the challenge is. Now, for all intents and purposes, I'm assuming that the petitioner is hanging her hat on the deliberate acts or series of acts just based on the information included in her pleadings. That, there were some folks on social media that made comments in response to a reporter, and therefore those are the acts or deliberate series of acts. Now, the caveat to the acts or deliberate acts is that those must be coupled with an act making it impossible to determine the highest vote getter. That is clear in case law. In many Indiana cases, look at Pavey, I can cite several different cases, but it is clear that it must be coupled with the making it impossible to determine the outcome of an election because there were deliberate acts or series of acts in certain precincts in a district. They must identify those precincts, which is also required. Identify what's going on, what happened. Here, as I state in my motion to dismiss, the petitioner has outlined every single precinct in the entire district, which encompasses 6 counties and hundreds of precincts, right? That there's nothing specific about a said precinct where no machine malfunction, ballots didn't print. I've dealt with election cases before where, say the polling site didn't open in time, or ballots, when we used paper primarily, ran out and people couldn't vote for a few hours. That's specifically what the General Assembly is speaking of, right? And so here we have the deliberate acts that I assume that they are contending are 14 in the original petition, 14 unknown individuals, right? 14 unknown people that commented days after the results of an election on social media about, in response to a reporter's article about the election results and hearing what I heard and this and that. And based on that, people saying, well, yes, I crossed over for Senator Deary. Well, yes, indeed, I'm this person and I used to vote this way. Now I vote that way. That's what this is based upon, which is 100% hearsay. There is no validation of who these people are, if that's really who they are. We don't know if the account tied to John Doe that made a comment is the John Doe that voted in Fountain County or Tippecanoe County, right? We don't know that. Nothing has proven that those people are who they say they are. If it's not a bot, if it's not a duplicate account.
30
if it's not
seconds.
Conjecture. The sole basis of this is based upon nothing but on hearsay, right? They're unknown, unidentified individuals that we can't tie a ballot to. There's no ballot tied to these people. So what they have done is challenge precincts of the entirety to toss out an entire precinct based upon hearsay of someone saying on social media that, oh, I crossed over. We don't know who that person is.
Time.
We don't know the seriousness of it. We don't know if that's even true.
If I understand, we only permitted 5 minutes, but if the commission would like, I think this is a big enough issue here that if the commission would like to allot more time for the parties.
As long as both parties are okay
No
with it.
objection. I agree with that.
Okay.
This is a key threshold issue.
Would you like to put a limit?
I move for no minutes.
Okay, perfect.
Thank you. And as we
We
all
need
know,
a second now for
oh,
that.
sorry, yes,
Or are
please.
we taking it by consent?
Oh, let's vote for the record. Are you in favor?
Second.
Second.
All in favor, vote aye.
Aye.
Against? The ayes have it. There you go. 5 more minutes more.
Thank you. As we all know, social media is exactly that, social, and it's in the public atmosphere. It's the statements on social media are not made under oath. I don't take most of what's said on social media to be true or even remotely accurate. It's a lot of gossip, innuendo. Here's pictures of kids, whatnot. I get friended all the time by people that are triplicates or duplicates of my current friends, or that are purport to be a soldier overseas that wants to be a friend. We don't know who these people are, where they live, what they do, and I don't really care. The important thing about social media is it's a public forum for free speech. That's where people make comments. People are allowed under the First Amendment to make comments on social media about whatever they like. People may not like it when they lose elections, but they are allowed to do so. That does not let the government come in and issue subpoenas to non-party innocent voters because of potential comments that yet have to be connected with who made the comment and the actual voter. From their own petition, they withdrew 3 different individuals they had named in their original petition because, come to find out, they don't even live in Senator Deary's district, so they didn't vote in the district. That's how little information they had filing this petition and still have. It's still based upon, well, this person said this, therefore they have to tell us who they voted for. That doesn't make sense on any planet to anyone. A voter's right to vote in secrecy and by secret ballot is fundamental. We have a fundamental right to vote as much as we have a fundamental right to a First Amendment to say what we want to in public forums. And to have the government, which is you guys, limit either one of those would be a tragedy, right? So that's why under Indiana code, contests and recounts are special statutory procedures. They are statutory in nature only. And what that means, they never existed in common law. They had to be created. They're a creature of statute. Therefore, anything outlined is what your duties are, what your authority is, what you are able to do. They would argue that you guys should expand that authority based on a statutory read of you can issue this and do that and anything else in general provisions. Does that mean you can issue warrants? Does that mean you guys can hold a jury trial? It does not. The General Assembly created this because it is to contest an election and overturn an election in the will of thousands of people has to have proven facts. Facts that are tied to ballots, facts that are tied to precincts, not just, well, my friend's brother's cousin at the grocery store told me that so-and-so voted for somebody else. I'm going to challenge it. This opens the door to other contests in the future based on what anybody says on social media, which quite frankly, no one should take that seriously or as the truth. And or you can contest an election, and or do we just start deposing the electorate, every election cycle, just take random samplings of different districts and depose people and ask who they voted for in a primary? Their time to challenge voters in a primary election has passed. That was when they voted in person, they could be challenged at the polling site. And it's clearly set out in Indiana code how to challenge a voter that you feel is not voting for the right party in a primary process. That was then when absentee voters signed an affidavit about, I'm requesting an absentee ballot. Here's my sworn statement about my party affiliation. That covers that. We don't now on the backside of an election, get to say, well, no, we're going to challenge all these people. But the only way we know how to challenge them, because we don't know if what they're saying is true, because it's 100% hearsay that wouldn't be allowed admissible in any courtroom. It's only used as demonstrative evidence, not as anything to prove the truth of the matter asserted. And they've attached it to pleadings. That's great. You can use that in the hearing, but I don't know what that's going to prove because it's 100% hearsay. 100%. It shows no proof of anything. The votes have been counted. Point to the 11 ballots that we should pull out because she wants to win an election so badly that we need to disenfranchise people and risk the future of elections by letting people contest based on hearsay and social media, which I can't believe I have to keep saying is ridiculous. That would turn the General Assembly statutes that they created and the authority they gave you on its head. You guys simply don't have the authority in jurisdiction. If it's not pled appropriately, you have no jurisdiction to accept under statute the petition because it doesn't spell out specifically what you are supposed to be looking at. It's all vague stuff. And if we can depose people, if we get more discovery, then we'll come back and report back and let you know what our facts are.
Time.
That is not the point of the contest statute.
Thank you, Attorney DeWester. I think at this time, we're going to hand it over to Attorney Book.
Before, I'm going to just get set up here. Before my time starts, would it be permissible if I introduce the people on our team that are with me today?
Is that okay with you, Commissioners?
Yes. Great. Thank you very much. So, of course, Paula Copenhaver, candidate and petitioner. Ted Murphy is an attorney with Kroger Garrison Regis. Sarah Pester with Kroger Garrison Regis. Kim Cross and Serena Cruz, also with our team from Kroger Garrison Regis. And my name is Bill Bach. I appreciate very much the opportunity to present to you today.
Mr. Bach, before you get started, would it be appropriate? Do you believe you're going to need more than 5 minutes?
I do, and I appreciate you asking me that. And so I will try to stay within the 10 that Samantha took. And I think it's very, very appropriate that she did. Because I think that this is an important issue. She got into some of the issues, as you heard, that deal with the subpoenas of voters, which is the last thing that's on the agenda. And I think that I can save a little time by hitting some of the key concepts about why we are on such obviously different pages. And that's going to inform us on 2 issues. And so I think that maybe hitting those threshold issues right at the beginning makes sense if it's okay with the commission.
I think that's
The commission would like to make a motion to maybe permit him 10 minutes.
Also move.
Second.
all in favor, say aye.
Aye.
Go ahead, Attorney.
And one last thing before I begin, and that would be that we filed a 57-page brief, and apologies. I know you probably haven't had a lot of time to read it, given that our deadline, we were responding to Samantha's brief the week before, and you've only had a 1 business day. I would urge that brief be read because as Samantha's made legal arguments and assertions, we've cited cases and statutes and that I believe support our position. And so I would urge, I'm not sure what the process is intended to be this morning, but I would urge that there not be a decision on this issue, at least until we get to the end of the hearing and hear the requests about subpoenaing the voters. But with that, I'd like to go ahead and begin. I think it's important because Ms. DeWester has told you that you don't have certain powers and that you can't do certain things as a commission. I think it's very important for this commission to understand why you're here. And the first is because there is a constitutional provision called the Free and Equal Elections Clause that's been in our Constitution since 1851 that I'm going to talk about a little bit more. So I don't think it can be doubted because your decisions are subject to appeal to the Court of Appeals, that this commission's duty is to exercise its powers consistent with the Indiana Constitution. And I want to tell you why the Constitution requires that you not count illegal votes in a recount or a contest. Second, you are required to obviously act consistently with the Indiana Election Code. I don't believe that the descriptions of what statutes require are accurate. I don't think that Ms. DeWester will be able to show you, and a challenger to show you, a statute that requires an illegal vote to be tied to a particular ballot. That is a myth. It's not in the Indiana Election Code. She needs to show you that because she told you that that's the only way that you can consider these votes. Third, the commission has to.
Counsel,
Yes.
can you distinguish between an illegal ballot and voter fraud?
An illegal ballot is one that the participant in the election was not eligible to make. They were not an eligible participant in the election. And I'll get to in a second the two statutes that make it very clear that in a partisan primary since the 1800s, one has only been able to vote in the party to which they're affiliated. The statute that we're talking about was dealt with by the Indiana Supreme Court in the Kelso case in 1916, a very similar statute. And they said that it's fundamental to protect partisan political parties, the Republican Party, the Democrat Party, whatever other party qualifies candidates on the ballot. It's imperative to protect them that they be able to have only their voters in the primary. So these votes, and the statutes back that up. So these votes of people that they may be eligible voters, they're not but are not eligible to vote in the Republican primary, are illegal votes, according to a long line of Indiana case law. So that's what I'm referred to in terms of illegal votes. Thank you for your question, Mr. Clayer. And then fourthly, it's the duty, I believe, of this commission to interpret its statutory powers so as not to create a conflict with the Indiana Constitution or lead to an illogical result. And we discussed that in our brief. So let me move on. Here are the key, I think, principles in our case. The Free and Equal Elections Clause, Article 2, Section 1 of the Constitution, the closed primary statute, which is Indiana Code 310-16, and the partisan challenge statute that allows individuals to be challenged at the polls if they are not a member of that particular party. Why is that important? Ms. DeWester has just told you that it's somehow violating the expectation of privacy of people if we then ask them how they vote. To the contrary, the closed primary statute says that you can only participate in a Republican primary if you voted for a majority of Republican candidates in the prior election. you're making an affirmation when you vote in the primary about how you voted in the past. And you can be challenged on that basis. And that's what the partisan challenge statute says. And not only that, you're making an affirmation that you will vote that way in the future. And so what you're then asked to do or told that you have to do in the challenge statute is you have to provide an affirmation if you are challenged. You have to tell who you voted for in the past if you are challenged. So our position is that when one votes in a partisan primary, they waive their secrecy because they're saying that they voted and how they voted in the past. And then in terms of the other statements these individuals have made, I mean, we brought before this commission 11 voters, the names of 11 voters. We haven't put them out there publicly, but they are attached and the commission has their names. They have their voter registration addresses. These are not people that we don't know who they are. Those people are specifically identified in our filings. So the free and equal elections clause. Kelso versus Cook, which I mentioned, an Indiana Supreme Court case, giving each member of a political party a free and equal voice in the selection of candidates cannot be accomplished without excluding those who adhere to other parties or to no party from the primary election. That is the law. That is how the free and equal elections clause in Indiana's Constitution is interpreted. That has never been changed. The Simmons versus Byrd case, another Indiana Supreme Court case, said when the ballot box becomes the receptacle of fraudulent votes, the freedom and equality of elections are destroyed. So if you have illegal votes, somebody is not entitled to vote in the election, the equality of elections are destroyed. That is the free and equal elections clause. Another Indiana Supreme Court case, 1958. It's a fundamental idea in all Republican forms of government that no one can be declared elected unless he or she receives a majority of plurality of the legal votes cast in the election. Okay, these votes were not legal. And then in that same case, the vote of every elector must be equal in its influence upon the result, the vote of every other elector. This is an important, the Hoffman case is an Illinois case, but it was cited by the Indiana Supreme Court in the Kelso case. And it says that that election is free and equal when all the qualified, because they have a similar clause in the Illinois Constitution. It's free and equal when the qualified electors are carefully distinguished and are protected in the right to deposit their ballots in safety and unprejudiced by fraud. That election is not free and equal, where the true electors are not separated from the false. Okay. And then a couple of other Supreme Court cases from North Carolina and Arizona. We cited other cases in our brief that applying their free and equal elections clauses. This was a very common provision in state constitution that to say that you cannot have illegal votes in an election and have a free and equal election because you're disenfranchising the electors that are entitled to vote for a Republican candidate. You're disenfranchising Republicans, and that's what happened in this election.
1 minute.
This is from the Pabay case, a 2004 decision of the Indiana Supreme Court. The court said, relying on an 1875 case, which was an election contest dealing with eligibility of voters, and that allowed the exclusions in an election contest of illegal votes of invalid voters. And in Pabay, the court said by the word votes, and that to apply, and they were applying the election contest statute here, that you were just told had to be tied to a ballot. That's not what the Indiana Supreme Court says. By the word votes, the legislature could not have meant it to include votes illegally cast. To impose such a meaning would render ineffectual the purpose of the statute. More than a century ago, this court recognized that the true gravamen of the case, whatever may be the ground of contest,
Time.
is the highest number of legal votes. So here, I would just ask for maybe an additional 5 minutes to kind of actually get into the details related to some of the other claims, because this is such an important issue.
Thank you, Mr. Brock. I think we're going to allow at least 2 minutes for rebuttal. Attorney DeWester can do that, and then as well, you will have 2 more minutes to rebuttal or say anything
Yeah.
you may wish.
That's fine, and I accept the panel's and the commission's ruling and the chair's ruling. But I was told that we could ask for additional time in order to have a full presentation and on this particular issue, given that it's obviously a threshold issue about whether you even go forward with a claim. That's why I was just asking for an additional 5.
If Attorney DeWester agrees with that, we can.
And I wouldn't have, I mean, obviously she would then have additional time for
Sure,
rebuttal.
that's fine. 5 minutes.
Well, we're going, commissioners, do you agree? 5 minutes, no problem. I so move.
A second.
Second. All in favor, say aye.
Aye.
But we agree for 5 more minutes for each parties.
Thank you very much. Okay. So as Ms. DeWester said, the primary focus of this action is 31211 3B4E of the contest statute. And I put the language up there, it's at the bottom, so that the commission can see that's what we're proceeding under. The candidate who received the highest number of votes cast in the election. And remember, the Supreme Court said in Pavey, that can't be illegal votes, okay? So a couple more Supreme Court cases here. I'm not going to spend a lot of time with them because our time is limited, but where election contests, where illegal votes were excluded without necessarily tying it to the ballot. At the bottom, if the voter wasn't able to distinguish his ballot and know which ballot he cast that was illegal, it's still competent for him to testify how he voted. And that's a Supreme Court case in Indiana. Now, if you look at B4E, which is the provision that we're proceeding under, it does not require the precincts where these things occur to be identified. It says identify each precinct or other location in which the act or series of actions occurred to the extent known to the petitioner. What did we do? We told you the name of the person who committed the violation, and we told you where they lived, which you can then find what precinct that they live in and vote in. Most of these individuals voted in Tippecanoe County. That's a vote center county. They don't even use precincts to vote. So we did all that was necessary in terms of giving notice about what we were concerned about and giving the other side notice about who we were concerned about. They had their names and addresses. So the idea that we didn't is not well taken. The petitioner says in their motion, petitioner or the respondent says petitioner does not confirm identities of any human beings involved. That's just false. We specifically named them and attached that to and incorporated that motion for subpoenas that have their names and have their addresses and incorporated it by reference. So, okay. Okay, sorry. the idea there's nothing in the petition to prove these people exist. Of course they exist because they're voters. Their names are on the poll list. We identified who they are. So that's not well taken. I want to go to this bulleted list on page 3. The claim is that we didn't identify actual or specific voters. As I said, we identified them by name and address.
1 minute.
The claim is that we didn't identify the statutory provision that was violated. We did. It's 310.16. With the claim, if you go down through every one of these things, and on page 3, on page 5, and page 7, she includes these lists. And we do this to a large degree in our brief. We have done all of these things. We have provided sufficient information. You know that we're here talking about 11 voters and whether their votes should count. So to dismiss the election contest would be inappropriate. We've provided more than enough information about what our claim is related to a contest. Everybody understands it. At the end of the day, after the final hearing, you may conclude that you don't agree with us on the law. But I think that we provided enough for you to allow this case to go forward and not find that they didn't have notice about the claims that they're facing. Thank you.
Thank you, Attorney Buck. Attorney DeWeister.
Thank you. It's not about putting me on notice, it's about putting the commission on notice and see if they have jurisdiction to accept a contest under statute, which is purely statutory in nature. It is not something that you guys can just create processes and whatnot for. The General Assembly has dictated what you can and cannot do and what is acceptable. And this is not a civil action. This is not a personal injury lawsuit. This is not a divorce case, right? This is not typical trial procedure. The rules of trial procedure don't really apply. Evidence don't really apply. AOPA clearly by statute doesn't apply. This is a statutory process to determine whether an election should be overturned and a special election happen or precincts tossed based on the face of a verified petition, right? So a verified petition was signed by the petitioner stating under penalties for perjury that to her belief and knowledge, these 14 people did in fact, they submitted invalid or illegal votes.
1 minute.
They mentioned fraud. I'm sorry.
1 minute.
Yeah, I guess 5, but more, right? 7.
7?
Yeah,
We get 5 minutes and then 2 for rebuttal.
So 7 total.
7. Excuse me, proceed.
She signs under penalties of perjury, which is a criminal act, that through her own personal knowledge and belief that she knows that these unknown people who she probably has no idea who they are outside of a comment to an article on social media, and then voter vaulting or whatever system, looking them up, these must be the people. They have no idea if that's who those people are. It's asinine to have with a straight face tell you that, yes, these people that commented have to be these people. They have the same name, they're on social media, because we know no one lies on social media and we know no one has a fake account. Why? The comments were made after the election, and they in fact removed 3 of the people that they had previously mentioned because they in fact, even though they said they pulled a Deary ballot, they don't in fact live in Senator Deary's district. So that was just a flat out lie. That should give you the innuendo and gossip that is what social media is. And this is not a typical civil action. That doesn't mean they state in their response that was filed late Friday night, 67 pages long, that a civil action is a preponderance. This is by no means a civil action, and that's made clear in all the cases that say this is statutory in nature. And also, it's referenced in PDB Pastrick that you must give, it must be conclusive evidence. Conclusive evidence. That sounds like clear and convincing at a much higher burden than a preponderance, right? Because voting is a fundamental right, to me, it is equivocated to criminal law, where the Constitution and the Bill of Rights are highly invoked. In order to show certain things, you must show why you should invade someone's privacy, why the government should be dropping subpoenas on innocent people, why the government should be disenfranchising individuals and saying their votes don't count because we think John Doe is this guy. We don't know how he voted. We don't know if he voted in this race on the ballot, but he said he did on social media. Therefore, let's strike that. Let's just kill the whole precinct. Let's take away 11 votes based on something that is not proven because of what it said on social media. I would love to know what case or statute defines this as illegal voting. I mentioned it in my response. They enumerated throughout their entire pleadings and he just went on and on about this is illegal voting. This is illegal. Where does it say that? It's not defined in Indiana code or criminal code. It's not fraud. So the cases, most of them that they mentioned, if not all of them, are based in another century, in another state, or reference criminal conduct. Haiti is one of the key Indiana cases on point that had bribery, ballot harvesting, voter fraud, absentee ballot fraud, registration issues, completely different than some people saying on social media, hee, I voted too. They are apples and oranges. That's not even a comparison to make, but yet we want the same kind of remedy to have a special election because they say that these people are the same people. So I guess we just take their word for it. If they know they are, then why do they need to depose them? Why do we need to depose anybody, right? And I don't know. I've never been told, and I guess the general public's now put on notice, that if you vote in a primary election for what they just said, you waive your right to secrecy. New knowledge for me. The General Assembly hasn't codified that. I haven't seen it in any case law I've looked at, but that's what they just said. That if you vote in a primary election, you are making an affirmation, and if you sign the affidavit, if something challenges you, you waive your right to secrecy. They said something on social media, therefore they waive. That doesn't make any sense. You don't waive your right to secrecy. You don't waive anybody's right for the government to intrude on my right to vote, my right to privacy, or my right to free speech. The bar is so high to encumber a fundamental right under the Constitution. It's baffling to me that we're even having this conversation about the silliness of social media and taking votes away from Hoosiers. I've done many of these. I see how hard these folks work. I've seen how hard the clerks work. And now we want to say people that went out and voted early on day of absentee, hey guys, sorry, your whole precinct's going to be wiped out. Because we think that this guy that commented on this newspaper article lives in your precincts and therefore everything should be invalidated because we think it's illegal. That makes no sense. That policy, law, it makes no sense to anybody. It's when we talk about Article 2, Section 1 of the Indiana Constitution, the fair and equal, yeah, that's for the voters. But is it fair to the voters that we would take away their votes because they think these people on social media should not be counted, and we're not sure if it's them or not because we don't know how they voted, and we don't know if they even voted in this race, and we don't know if they really are.
1 minute.
I haven't heard anybody say they dropped subpoenas on Facebook. My guess is I can know the response with Facebook responding to a subpoena request for data as to who the people are would be no. But it's all hearsay. We don't have an elevated, heightened scrutiny contest petition in front of y'all to disenfranchise voters based on 100% hearsay. That makes no sense to anybody.
Thank you, Attorney Wesser. We got 2 minutes of rebuttal from Attorney Buck.
Okay, thank you. Taking into consideration that last thought, it's 100% hearsay, right? She's talking about the evidence in the case. She's not talking about legal issues related to a motion to dismiss. So this is not a motion for summary judgment. It's a motion to say that we can't even go forward on our claims. So it shouldn't be because we don't know who these voters are. That's why we're asking for a subpoena. We need to be able to ask them these questions, and then we'll get later to the question about their privacy interests. But that's certainly not a basis to dismiss. That would be a basis for a motion for summary judgment. She says that voters don't waive their interests. She's never heard of a statute where there has to be an affirmation or an affidavit. It's right behind you on the screen. It's a partisan challenge statute. that a voter who resides in a precinct may challenge a person in a primary election
1 minute.
on the very topics of whether they're eligible to compete or to vote in the primary election. And that includes how they voted. They have to sign an affirmation or an affidavit saying how they voted. Of course, you waive your protection related to that qualification on the ballot. The fact that people don't get asked that question a lot doesn't change the law. And it doesn't make it legal or valid for somebody to step in and vote when they're not qualified and not an appropriate voter within the primary. Last point. We keep hearing that we've asked for a special election. She didn't read our brief. We're not asking for a special election. Special elections not required. Those cases that I showed you suggest
Time.
that. We're asking for the exclusion of illegal votes, not a special election.
Thank you, Attorney Burke. At this time, I'd like to ask the commissioners if they have any questions. Commissioners? Any questions to the party or anybody?
No questions for me.
No.
If there are no questions, I'll believe at this time, yes, Attorney Kraft.
Yes, thank you, Mr. Secretary. Members of the commission, I think at this time we need to address if and how a ruling will be had on the motion here. As I mentioned at the start, this is a threshold issue. And my understanding is that by statute, it must be a motion to dismiss of this kind must be ruled on before the contest, any more of the contest portion it may proceed. I would request the input of your counsel, but my understanding based on that is that I do not believe the commission can rule on any of the other motions we are going to hear today prior to a ruling on this motion. Therefore, if that is correct, and please tell me if I'm incorrect, I'd be interested in knowing how the commission wants to proceed. If the commission believes they're ready to rule, we can move to that point. If the commission feels that they need to hear the other motions to be presented today, I believe we could remain in compliance with the statute if they could hear those motions, but they could not rule on them until and then hold rulings until the end. However, I believe if the commission wishes to rule on any of the motions that are going to be heard today here at this hearing, they will need to rule on this motion to dismiss.
I'd like to respond. Could I respond?
Will the commissioners allow for Mr. Burke to respond?
Yes.
So I don't think that that's accurate because this hearing was set when we were just dealing with the recount, and it was set before this motion was even filed. So most of the motions do deal with issues related to the recount, number one. Number two, our position is that the recount and election contest issues are overlapping, that we can get the same relief under either statute. So I just want to make that position very clear on the record that we believe that each of the remaining issues relate to the recount, that there's been no motion to dismiss the recount. And so I don't believe that this is a threshold issue that has to be decided by the commission now. I think that we have moved because of the fact that we see that there are overlapping issues. We've moved for consolidation of the hearing and just one final hearing dealing with both the recount and the election contest. Thank you.
Mr. Chairman,
Uh,
I move we dismiss the contest portion of the petition.
Commissioner Claytor, do we have a second to dismiss? Is that what you were trying to work here, Commissioner?
Yes, my motion was to dismiss
To dismiss and reject the contest.
only the contest.
Only the
portion of
contest portion.
petition.
Any questions?
If there's no second, my motion fails.
The second,
I move to deny the respondent's motion to dismiss.
so you move to deny. Can you say that again, Commissioner?
I move to deny the respondent's motion to dismiss.
Is there a second? Second. Those in favor say aye.
Aye.
Aye. Those opposed say nay.
Nay.
The ayes have it.
Possibility that you guys could state on the record your reasoning as to why.
I would like to explain my vote. Thank you, Mr. Chairman. For many years, I have not enjoyed contest petitions that are not backed up by the statutory requirement. I read the statutory requirement as being something that happened in a precinct or location. I read location as being either the courthouse or vote centers. And therefore, I believe that the statute requires specificity. If there had not been a motion to remove the contest portion, I would have asked the commission sua sponte to make such a motion. And that explains my vote.
Thank you, Commissioner Claytor.
Explain my vote, based on the arguments in the briefing, and they meet the good faith standard.
Of specificity? And based on your side?
That's the explanation of my vote.
Well, thank you all. At this point, we're going to move to the second item, I believe.
Yes, Mr. Secretary, thank you for that. So now with the motion to dismiss, just to clean the record, the motion to dismiss now has been filed by Senator Deary, has been defeated 2 votes to 1, with Secretary and Commissioner Mullen voting in favor to deny the motion to dismiss, and Commissioner Claytor voting to deny the motion to deny. So with that, we will now move on to the second discovery issue, which is per the agenda that was recognized at the beginning of the meeting, which would be, I would call Deputy Director Plopper to make a brief, just very brief presentation on the subpoena issue to the Tippecanoe County Clerk, which I believe is the first issue. Yes, it is Copenhagen's subpoena to produce documents or things to the Tippecanoe County Clerk, Miss Julie Roush.
Thank you, Director Norris. Before we proceed with summary of these pending motions, I did have some preliminary discussion with petitioner and respondents counsel regarding how these could be presented. The 4 pending motions that I'm going to present to the commission today have a lot of overlapping issues, and I would seek Director Norris's counsel or the commission's preference as to whether or not a couple of the presentations could be combined. Specifically, petitioner subpoena to produce documents to Clerk Julie Roush, and also petitioner Copenhagen's subpoena to produce documents to the Tippecanoe County Election Board. If petitioner would like to combine presentation on those 2 motions, I would seek the commission's approval to do so if that's their preference.
Yeah, thank you.
Thank you, Attorney Plopper. Well, I believe we're going to allow the parties as well for 5 minutes to, obviously state what you need to say in your 5 minutes. And if we need more time, we can go from there.
But in order, you're talking about combining.
Just because there's overlapping issues and to avoid repetition as a suggestion, but we can take each motion in turn.
Take them. I recommend that we take them in turn so that we have a clean record at this point.
Does the commissioners agree?
I would prefer to take them in turn. Yes.
Okay.
Perfect. Okay.
Thank you, Director Norris.
Consent.
Thank you, Mr. Secretary. The first pending motion that we're going to consider momentarily here is petitioner Copenhagen's subpoena to produce documents or things to the Tippecanoe County Clerk Julie Roush. Petitioner has asked this body to issue and renew document subpoenas directed to Clerk Rush to obtain records concerning a single vote that was added to Spencer Deary's vote total after the election night. According to the motion, Tippecanoe County initially reported its election results without this vote, but the following day, one additional vote for Deary was added without Petitioner Copenhaver characterized as any official action or public explanation by the clerk or election board. With that, I'll conclude my summary and allow petitioner's counsel to proceed.
Before I start, can I just have clarity? Are we on item 3 of the agenda, which would be the request to issue a deposition subpoena? Or are we, or is it the request to produce documents?
Document subpoena to the clerk first, then document subpoena to
Okay.
Tippecanoe County Election Board, and then we'll get into the deposition. So let's just take the first one, subpoena to the clerk
Okay,
for documents.
sure. Thank you. Okay, so then this is what the allegations in our complaint were. When the complaint was filed, all we knew was that a vote had been added the day after the election. Every precinct was reported, 100% of the precincts were reported on election evening. And then suddenly, the next morning, there was one additional vote for the respondent that was counted. We later have learned what we believe or what we may know about this absentee ballot. When we went up there, our team went to Tippecanoe County on June 16th and had the opportunity to talk with the voting technician up there, the election vendor that's used by the county, as well as some of the personnel that were there. We were told was that this was a mailed absentee ballot that was found in the bag with other ballots in a corner of the Tippecanoe County Courthouse the day after the election. And it apparently was unilaterally voted by the Tippecanoe County Clerk without oversight by any other election official. And that was apparently accomplished by asking the county's election systems vendor to just add the vote add the votes from that absentee ballot to the county's central count tabulation. And we know for certainty that no official action was taken by the county election board. We don't believe any official involvement happened from the absentee ballot counters. So if that's our understanding, that violates all kinds of provisions related to absentee ballots, as the commission's well aware. Some of what we don't know, we also were told that absentee ballot, we don't know how this is known, but that it came from a vote center and somehow didn't get counted on election evening. If it came from a vote center, as we explain in our brief, this is an invalid vote because that there isn't an opportunity to vote through a mailed-in ballot through a vote center. But there's much we don't know. How the ballot was delivered to the vote center, whether the person delivering the ballot to the vote center was authorized to do so, because only the voter can mail it in or take it into the clerk's office unless an affidavit's filled out by somebody that's assisting the voter. There's no, in the materials related to this ballot, no assistance form. So we don't know, though, whether somebody was assisting them and they didn't fill out the affidavit, which would obviously invalidate the ballot. So how was the ballot transported to the courthouse and by whom? Who had access to the ballot between election day and the following morning? Was the absentee voter signature validated? As the commission's well aware in the Horseman case, the Indiana Supreme Court made very clear that there are heightened standards in Indiana law related to absentee ballots, particularly mailed ballots, because of the opportunity for potential coercion to the vote on the voter and the various opportunities for influence of that ballot. That's why the Indiana code treats mailed absentee ballots different. And it makes them not valid if, for instance, there isn't sufficient chain of custody. They're not valid if the absentee voter's signatures is not validated. And we have no evidence that that signature was validated. Nothing that we've been provided has told us that.
1 minute.
So here are some of these legal questions about why questions about these absentee ballots matter. And so that is why we're just asking for subpoenas to the county that just ask for the documents related to this absentee ballot, which we haven't received. And to confirm, we will later ask and talk with you about a subpoena to the clerk that relates to this. I won't go beyond that now, but that's why we're asking for these documents. Thank you.
Thank you, Attorney Buck. Attorney DeWester.
Yes, so my response, and I asked opposing counsel this many weeks ago, have you tried making a phone call to the clerk, having a conversation? That's probably the easiest way to accomplish what you're trying to accomplish, as opposed to continuing to abuse taxpayer time and money with, people that work for the government via depositions and document requests. Ask them what happened. At the end of the day, this is not a trial. You don't just get a limited discovery request because you're trying to find one ballot that points to something nefarious, apparently. And if they would make a call and find out what happened, their request is for documents to not just the clerk, the election board, and other relevant personnel. I don't know what that means, right? Discovery 26C is fairly clear on being narrowly tailored. This is a very heightened procedure that we are going through. Just having unfettered discovery, will drag it on, which is what the courts have said in many cases. People have been waiting 3 months to get the results of this election, and they still don't have them. And here we are having the same conversations about ghost people, unknown individuals, and a ballot that was already counted. They can't identify the ballot because it's been counted, right? So we're just going to say that that person should not be allowed to vote there. If there was an issue if someone dropped it off, which Tippecanoe County, by the way, adopted vote centers, it's all online, and vote centers are allowed to take absentee ballot returns if they are so appointed by the election board, again, all online, and talking to the clerk to resolve those issues. So I don't know why belaboring this and sending out pages and pages of requests for discovery and depositions to get an answer about one ballot. This is not a series of actions of 400 ballots were dumped off overnight. I don't know where they're getting the story of it was left in a bag in the corner. I've never been told that until I read their response. We don't agree to it, contrary to what their response says. So we object to further belaboring this and in the intrusiveness to government elected or government employees that are paid for by us for their private matter that they're challenging because they want to find something about a vote just so she can win an election. It's ridiculous.
Thank you, Attorney DeWester. At this time, we're going to allow the 2 minutes rebuttal for each party as well.
Okay. Well, I would think that we all have respect for this process because who wins an election is important and it does matter. And it's worth taking the time. It's worth taking the time to make sure that that's accurate. And that's why the commission has these powers. It has the power to issue subpoenas, discovery orders, and protective orders. And number 6, exercise any other necessary power to perform its functions under this article, because what the commission is doing is fundamentally important. And, the idea that, that this is going to take up time when we're talking about an absentee ballot that was just potentially voted by an election official, possibly in violation of their duties, and we're just going to ignore that in an election that is separated by 1, 2, or 3 votes, just absolutely does not make sense. Last point is,
1 minute.
is that I challenged Ms. DeWester on this at the beginning. She made the argument again before you just now that you have to tie the ballot in order to eliminate the vote, you have to tie it to a particular ballot. I challenged her to show you the statute that says that, show you the case law that says that. We know that this ballot was voted for the respondent because that's his vote total went up 1, and nobody disputes that. The election technician knows who that ballot was voted for, and he told us that. So we did actually talk with people, but she keeps saying you have to show us the ballot and and the ballot's already been counted. That's wrong. This is a recount, and the invalid votes can be removed in a recount or an election contest. Thank you.
Thank you, Attorney Bob. Would you like to rebuttal, Attorney DeWester?
Yeah, in the case of Shopstall and Kaepernick, you want to know that it specifically states that a general adjustment to a ballot count is not contemplated when a court is dealing with a recount, you being the court. So it is tied to a ballot. It's not just a general adjustment. We'll take 2 off here, 3 off here, and here we go with the winner. That is what it says. Again, there are many easier ways, more easier to accomplish what they need to, like a simple phone call. They have lots of information, it sounds like, through a communication circle about what may or may not have happened, instead of just calling the person directly, the clerk, and finding out what's going on. So if we can't even begin by picking a phone to get a question answered, why do we allow an intrusive form of information gathering like discovery? I understand what number 6 says, and they hang their hat on all other duties. I'm pretty sure the General Assembly would disagree with you in that you guys can exercise any power necessary to perform the duties under Title III. Like, that's why I asked before, can you guys issue warrants? I mean, that doesn't mean that you can just ad hoc issue discovery orders, intrusive in nature for depositions and whatnot.
1 minute.
A recount is a recount of the votes. You just heard that it didn't change. That's the certified vote total. So now we're going to go in search of other things that could overturn that. And it's not tied to a ballot. It's tied to, again, hearsay, because they haven't even talked to the direct people involved. But instead of doing the easiest thing, we're going to go to jump to the hardest thing possible and on taxpayer time and dime.
Thank you, Attorney DeWester. At this time, commissioners, do you have any questions for both parties or anybody here? For the attorneys?
I do not.
The only thing that I will add is logistically, and I'm not obviously taking any position on the request. Remember that the request here is for Copenhagen to issue a subpoena. And so necessarily as part of this process, I would ask of the commission also, if the commission moves to accept the request and issue the subpoena, that they also tie a number of days for the subpoena request if a motion is so made. A days for the clerk to respond, because a subpoena will have, 7 days, 14 days, 21 days, so on and so forth to respond to the subpoena. And so that if the commission is inclined to grant the request, I would ask that they tie the number of days for the clerk to respond to that as well.
If I could add a few points as well. Thank you, Director Norris. I would draw the commission's attention to Appendix B of petitioner's petition. It contains the form subpoena that's being requested this body to issue. Motions that could be made at this time. If you're inclined to rule on this motion now, you could move to approve the request. You can move to deny the request, or you could continue it, which I don't think would be a prudent action. But if you move to approve the request, you could also have some discussion about limitation of scope of the subpoena.
Commissioner Morley has a question.
I have a question for both parties. And I'll start with petitioner first, but I guess do both parties agree that the ballot was delivered to a polling place on election day?
We haven't seen evidence of that other than that's what people have said. at the county level.
Have you seen evidence that's not, I mean, have you seen evidence in the other direction?
No, no. Respondent stated that that it was found at the vote center, and we made our arguments in our brief on that basis, because if it was delivered to a vote center for the reasons in our brief, we don't believe it could be a valid ballot.
Yes, it's my understanding that it was delivered to a vote center. It was accepted by the election personnel. It was then returned to, when you close a polling site at night on election day, if you work with polling sites, you would know. It's all then returned back to a central count location. Tippecanoe County has adopted the vote centers and the absentee ballot returned to a dedicated vote center entity under the what the election board has adopted as well.
Thank you. If Recount Director Norris has no other comments or other attorneys, I think it's safe to make a motion whether to. I do have a recommendation. The recommendation that it will be up to the commissioners to decide what to do. The recommendation that I have in this case is to reject the motion to subpoena the Tippecanoe County Clerk and Election Board. So.
Is that in the form of a motion, Mr. Chairman, or do you want me to make that motion?
You can make a motion if you.
I would accept your motion as mine.
And I'll
Yep.
second that.
Do I have a second?
Yes.
All in favor, say aye.
Aye.
Opposed? The ayes have it.
Right, so we will show that petitioners, go ahead.
Yeah, if I may, Mr. Secretary, you got a point of clarification. I believe stated in your motion was that the subpoenas you would recommend to approve they be served to the clerk as well as the
No.
election board?
No, it was to deny,
Oh, to deny.
to reject, yes.
Okay.
And it was approved. So I will show that for the record, the Copenhagen subpoena to produce documents or things to Tippecanoe County Clerk Julie Roush has been denied by a vote of 3 in favor, 0 opposed. And so with that, we will move on to very quickly I'll just go ahead and just briefly introduce this one. This is the same, my understanding is the same general request, Copenhagen subpoena to produce documents or things to the Tippecanoe County Elections and Voter Registration Board, which is attached as Appendix C to the petition. With that, I believe that the parties are prepared to make brief written or brief oral arguments to that effect. Again, for the commission's background, same general subpoena, but I will let them address those issues.
The secretary said that he made a motion to reject any subpoena being issued to the clerk and election board, and that was voted upon. So I just want to clarify.
You did say that.
I did say that.
Okay, all right. Thank you for that. With that, then I guess we will move on then to the request for the commission to issue a deposition subpoena to the Tippecanoe County Clerk. I believe that's the next issue then, which is candidate Copenhaver's request. And so with that, give candidate Copenhaver counsel 5 minutes and then 5 minutes for response and 2 minutes for rebuttals.
The issues here are very similar, except that obviously what we know is that this vote or this ballot was voted by the Tippecanoe County Clerk.
Sorry, this ballot was what?
This absentee ballot that was found in a bag of ballots in the corner of the county courthouse on the day after the election was voted by the Tippecanoe County Clerk on the day after the election. She was not supervised. It was not accepted by official action of the county election board. There's no evidence that we have that there was any signature verification of this ballot, because that would have had to been done by the absentee ballot counters or the county election board. So the clerk, knowing that this was one of the closest elections in Indiana State Senate history, and that at that point only two votes separated the candidates, and she would have known that morning. She took the ballot out of the bag, opened the ballot without supervision or involvement of the election board, counted the ballot without supervision or involvement of absentee ballot counters. So there could have been no proper signature verification on the ballot. There could have been no understanding of how the ballot was protected in terms of chain of custody from the time that the ballot got deposited overnight and left in a corner at the county courthouse. And again, as I said earlier, no knowledge about whether the other requirements related to how the ballot was cast or was delivered were known to her. And this county official made the unilateral decision in one of the closest elections in the history of the state to vote that ballot unilaterally without any oversight. And we're asking that we have an hour of her time, maybe an hour and a half, ask her those questions so that we can present the evidence at the final hearing in this matter about whether the Recount Commission should count that vote, whether the requirements, the sanctity and security and safety of the ballot have been complied with. And all that information is in the hands of the Tippecanoe County Clerk. And she is a public official. And public officials are obviously, they're sworn to do their duty. And they should expect questions. And they should expect to be transparent. And frankly, Petitioner Copenhaver is entitled to know how that ballot got voted. And the public is entitled to know and understand and see that this commission considered whether that vote should be counted. And without a deposition and that opportunity to ask those questions of the county clerk, this commission will never know. Thank you.
Thank you. Attorney DeWester.
Thank you. It seems like the petitioner has a lot of information about ballots in a corner and unilateral decisions without even speaking to the actual clerk herself via a simple phone call. I'm just baffled by it. But a deposition is far more intrusive. A subpoena for deposition is far more intrusive to a subsequent elected official of the secretaries who oversees the elections. I'm guessing, I'm not going to put words or thoughts into her head as they have just done what she made decisions about or thought. But I know that clerks are extremely busy on election night. When polls close, it's a frantic, firehouse trying to get everything in, locked up, secured, accounted for, systems closed down, things like that. I'm pretty confident she wasn't worried about or watching the results in one race, and is also concerned about all of the other races down ballot, right? So I would ask that, again, my response was objecting to any subpoena being issued for a deposition when there are much easier ways to obtain information that they are seeking. And again, there is no ballot and there is no way to tie anybody to a ballot outside of them saying it came this way, which again, Tippecanoe County has adopted a vote center thing, which is online. And that they can obtain the information in much easier ways. Call the clerk, ask her how it happens. There's no way if they were to say, administrative, they didn't follow this. It's pretty clear throughout many cases in Indiana election law that the voter should not be held accountable for a mistake or a process difference, etc., from an election official. If they weren't going to receive it at the polling center, the vote center, they should have rejected it. They didn't. They accepted it. Person carried on. Now we want to fight about the vote counting after an election has been completely concluded. So I would ask that be denied as well.
Thank you, Attorney Wester. I think we have 2 minutes for rebuttal.
Thank you. And in the Horseman case, the Supreme Court said that's exactly the situation's different with absentee ballots. That's why if you don't have poll clerk initials on absentee ballots, they cannot be counted because those ballots are treated differently. And so it's not the case that you can just wave it in. If it wasn't, if the requirements of the statutes weren't met with respect to absentee ballots, this commission will ultimately make the decision, but it has a strong basis not to accept the ballot. So that's number one. And this idea, which is pure speculation, that we can get information from the clerk by phone. This, keep in mind, Tippecanoe County, of course, is the respondent's home county. And I can tell you that we have diligently attempted to get information
1 minute.
from the county clerks for weeks in some cases, and it really depends on the county. Some counties are very responsive, and I'm not going to call somebody out here publicly, but some are not. So this idea that somehow we are not entitled to a subpoena because we could pick up the phone is speculative and baseless. And this is, again, an important issue. And we are entitled to try to figure out the best evidence that we can present to this commission about how this ballot was handled when we get to the final hearing. So we ask for the commission to vote for subpoena, allowing a short, and feel free to put a time limit on it, an hour and a half deposition of the county clerk, so we can just ask her those questions and have a solid record to present to this commission. Thank you.
Do the commissioners have any questions?
None for me.
Recount Director?
Yeah, thank you, Mr. Secretary. Very quickly, I will just add that again, the motion or the request here is for this commission to issue a deposition subpoena to the clerk, Julie Rauch. I might offer, as if the commission feels as though that they want to grant this request, that they maybe permit the recount director to authorize the issuance or to execute the subpoena so that we can work with the clerk to obtain her availability and location if the commission so chooses to initiate this process. I would recommend that you assign the authority to me as the recount director to execute that subpoena if necessary. Just throwing it out there as a logistical portion.
Thank you. Well, if there are no questions from the commissioners, then we need to make a motion either or to reject or accept. I make a motion to reject the motion to subpoena, issue a deposition. So let me go back. I make a motion to reject the motion to issue a deposition to subpoena the Tippecanoe County Clerk.
Second.
All in favor, say aye.
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 All opposed? The ayes have it.
Thank you. Secretary will show that candidate Copenhaver's request for commission to issue deposition subpoena to the Tippecanoe County Clerk has been denied with a vote of 3 in favor of denial and 0 opposed. At this time, Mr. Secretary, we've been going about 2 hours at this point. I didn't know if the parties wanted to recess or do we want to continue on at this point?
I think it will be wise to take a 5-10 minutes break.
Yeah, I would recommend maybe we come back at 11. That's a good round number. It's 10:50 right now.
Come back at 11.
Okay, perfect.
Thank
We'll adjourn then. Thank you. Mr. Secretary, relax.
Okay,
Thank you.
we are going to reconvene. I will hand it over to Recount Director Norris to proceed.
Yeah, thank you, Mr. Secretary. So when we last convened, I believe the discovery motion number 4 or 5 now that after the motion to dismiss, this will be number 5. We are going to deal with Senator Deary's motion to subpoena petitioner Copenhaver for deposition. That is our next request that is being made. So I would again ask the parties 5 minutes, 5 minutes, 2 minutes, and please, if there's been arguments already made on a particular issue, maybe just quickly highlight that, and so we don't have to trudge over that territory any further. So with that, I turn it over to Councilor DeWester.
Thank you. Yes, I did submit a motion to have a subpoena issued for deposition for the petitioner. She's a party to this case. I have every right to question her. It'd be brief. I've reached out to court reporters. We could do it via Zoom at her convenience in the next 7 days. Shouldn't take more than a couple of hours. She filed this case and has asserted lots of things in them. So I would like to question her about some of that stuff, which I'm entitled to do as she is the party who filed this.
Thank you. Attorney Box.
I guess I won't fault Samantha for not just calling to talk to her.
She's represented by counsel.
I know.
Yeah.
So, our position is that any subpoena that goes to the validity of votes should be granted. So I just would ask the panel and the commission to dig down on why this has anything to do with the validity of votes in the recount or the contest, because that's what this panel ultimately has to issue. That's why we've sought our subpoenas. These are political events as well as legal events, and I just want to make sure that there's legal relevance. I haven't seen it in her motion, haven't heard it in Ms. DeWester's request and explanation. How does this motion relate to the inclusion or the exclusion of votes? Thank you.
2 minutes, rebuttal.
Well, I mean, her verified petition is still pending. My motion to dismiss was just denied. So there are a lot of facts that she sets forth under oath in that, but I certainly have the right to question about where, when, why, how. She's the party. She's the petitioner. We're the opposing party. I have to make defenses for my client based on her verified petition. Therefore, I'm entitled to depose her. I don't have to jump through certain hoops. If he's asking for a protective order, that's a completely different conversation for a different day. But it's based on what you should tell me or question me about. But it's litigation 101 or Civ Pro 101. She filed a case bringing in non-party citizen voters and alleging all kinds of voter fraud and whatnot. So I'm allowed to ask her about that.
Attorney Book.
I still haven't heard a response regard to how this is going to lead to the inclusion or exclusion of ballots, which I think is what this proceeding is about. That's it. Thank you.
Do any of the commissioners have any questions? Recount Director.
No, Mr. Secretary, I will just note that, again, this is a motion by Senator Deary to subpoena the petitioner for deposition. So again, the respondent here, Senator Deary, is asking for the commission for permission to issue a deposition subpoena. So if you're in agreement with the issuance of the deposition subpoena to Ms. Copenhaver, vote to agree, or if you disagree with the issuance of that subpoena, you can vote to disagree or some other in between.
Thank you. Well, if no one has any questions, I'd like to make a recommendation.
I got one quick question to both parties. At any point, has Ms. Copenhaver suggested anywhere that she's a firsthand eyewitness to any wrongdoing or any material matters?
No, she was not in Tippecanoe County. She doesn't know any of the voters that were alleging cast illegal votes in the election.
But I will say, he made public statements as soon as this issue was filed about there's evidence of widespread fraud and whatnot that has been discovered and illegal votes and everything. And she signed it with her information and belief to the knowledge known to her that this is true.
I mean, can I ask counsel let me rephrase it differently. Does Ms. Copenhaver have firsthand information, eyewitness information, that she can testify to as firsthand eyewitness to material matters?
No, and she's not going to testify at the final hearing related to any of those things. Our case is she's required, every petitioner is required to file a verified petition. That's a requirement of the statute. So on advice of counsel, she signed the petition. But she's not a witness, not going to be called as a witness, and doesn't have firsthand knowledge of the issues that we're raising. She has knowledge of of the general facts in the complaint, the things that we've discovered through our investigation, but she's not going to be testifying about those things.
And I guess with Mr. Westward, the deposition, I mean, if assuming that's true and you may have contrary information that's not the case, but would it just be about her opinions?
Well, if she signs something under penalties for perjury that she knows the aforementioned facts in a voluminous petition are true, what does she know? He just said she doesn't have any firsthand knowledge. Therefore, that negates the verified petition itself. She doesn't have firsthand knowledge of anything, and therefore belief to her knowledge about anything being true clearly is not true because she doesn't have any firsthand knowledge of it. It's all hearsay, which is what my argument was with the motion to dismiss. So I certainly get to ask where she got this information from whom did it come, where did it come, why did it come, what was the basis of this filing? I certainly have the ability to ask. She filed it. She's the party that filed it and said under oath that I swear or affirm that everything aforementioned is true. Under penalties for perjury.
That's all. Thank you. Thank you.
Any other questions?
No, Mr. Chairman, I move that we deny the motion to subpoena petitioner for deposition.
Is there a second?
I'll second that.
All in favor, say aye.
Aye.
Aye. Reject? No, the ayes have it.
Thank you. Let the record reflect then that Senator Deary's motion to subpoena petitioner for deposition has been denied by a vote of 3 in favor, 0 opposed. Next, commissioners, we will turn to what is entitled as Copenhaver's objection to the untimely and unauthorized alteration of certified election results and request for emergency provisional relief from the Indiana Recount Commission. Mr. Secretary, at this time, I guess I would turn to the parties and ask, this is related to the Park County issues, correct? That's what this motion is related to. And the Park County ballot has been marked as an exhibit, correct?
Correct.
I would recommend that maybe we withhold or set this in abeyance until we actually go through the ballot disputes and withhold further arguments on that until that time, if the commission will agree with that, because I think it's probably more appropriate to deal with this during the actual ballot dispute discussions at a future meeting as opposed to today. Is there any disagreement with that?
I don't necessarily object. I mean, part of our thought is that, is that this is kind of a threshold issue related to consideration of that ballot. So as long as before it's considered that we can make our arguments at that time, that's fine with us.
So that's fine with me as well. I was just offering as a way to go about it. So with that, then, if the commission, we can proceed then on that.
I just one point to make about that, reading sort of the reply brief from Friday night. The motion to me seemed to be sort of threshold for the entire recount. Are you starting the recount with a 3-vote margin or a 2-vote margin? So just putting that out there.
Yeah, and I agree with that. I mean, because I don't think that vote can be counted or should be counted, because we're saying that it shouldn't have been included as part of the SBOA's account or their counting of the ballots.
Their tally. Okay.
But whether that gets addressed, at the very beginning of the next hearing or not is immaterial to us, but we're happy to address it today as well.
Go ahead.
I will just add that since the matter, and if I recall being in Park County correctly, is that the ballot was actually found, that ballot has actually been disputed. So it is an exhibit. I'm assuming that the reasonings for the dispute are going to be the same reasonings that are in the motion to object. And if that is the case, then I think it's all threshold. I think the arguments by the petitioners can be made at the time that disputed ballot comes up, and so that they will not miss any opportunity to make all the arguments they feel necessary to prove under statute to have that disputed ballot uncounted. But I want to make sure that I'm accurately reflecting what Mr. Bach is asking the commission here. But those are just my initial thoughts based on what I know and what was done at the Park County Government Center.
Yeah, I mean, it's not our position from the standpoint that we don't think, so we think that this ballot can be presented as a disputed ballot by the respondent, and who would then carry the burden of proof on the issue of whether or not the ballot can be included, because the commission took jurisdiction when the petition was filed and confirmed that jurisdiction by issuing an impoundment order. And at that point, any actions by county election officials were void and without authority, because the commission had authority at that point. So our position is what it says. It's the unauthorized alteration of certified election results. No one, the election division, the county election officials, no one had jurisdiction over changing the results after the filing of the petition, and particularly after the impoundment order. And so if the commission agrees with that, it's a 2-vote margin, and it's up to Ms. DeWester then to establish that ballot should otherwise be counted. We don't disagree that she has that right, but our position is a threshold issue of where we start, because our position is that the commission's jurisdiction was essentially violated by the inclusion of this ballot after the petition was filed.
I do need to state a couple things as to our factual nature. I do need to look this up. I anticipated on going specifically in here, but as one of the councils at the election division, I'm well aware of the changes in the results and the certified results in Park County. I will tell you that it was done in compliance with statute. The county found a ballot that was properly counted according to them. They needed to unlock their election results that they'd already filed with the state through SVRS. That was final. That was done within the statutory window under 312.5. And I closed my book. I believe it's 19. I will find that for the record. I'm sorry, but it's subject to 14. Yes, I'm sorry, 312.514. But it was my understanding that change was done definitely before an impound was issued.
Absolutely not. It happened on the 21st. Impound order was on the 19th.
I need my phone. In any case, actually, I do want to get to my point. The threshold is 3. We have certified election results at the election division. I will dispute any argument that the Indiana Recount Commission can tell the Indiana election division what documents it has. Park County certified their results. That certified results are mentioned in the State Board of Accounts reports. That is what is on the document that will be canvassed by the election division until someone of some judicial authority tells the election division otherwise. I have told my co-director, my boss, that particular matter. We will see what happens when we eventually get to the actual official canvass of the state legislative results from the primary, which has not been done because of this recount. But at present, based on what is in SVRS, which is in our canvass vote report, that the election division will sign after this recount is completed, and that a certification we will give to the Secretary of State as required by law, that current separation of the candidates, the difference in vote is 3. It could be reflected as 2 based on the recount stuff. I'm not disputing any of those arguments, but for right now, the fact remains that what we have in SVRS, which the election division considers as official, and which I fully expect for them to sign off on the canvas as required by law, that difference in vote is 3.
And our position is that's not how you should read the statute, that the election division didn't have jurisdiction to open that up particularly after the impoundment order, but after jurisdiction transferred. And that's well covered in our brief, and described in our brief. And we cite the statutes. I'm familiar with the statute that you're referring to, Matthew, that allows that references in some cases potential changing up to the date at which a county chairman can make a change. That one of those statutes refers to if it changed the results of the election, so that it doesn't apply. But the second statute that has that reference, I think the best reading of that statute is that it's the deadline is when the candidate can no longer file a recount, because otherwise the candidate doesn't file a recount, the election results are changed by a county clerk, and the candidate's left holding the bag. And unless they can get a county chair to overturn or to file for a recount, they've been cut out of the process because of the late filing in a situation like what happened here. So that's why the best reading of the statute, the most consistent reading of the statute, the one that prevents an absurd result like that, is the statute and the election manual both refer to a final decision on certification by the second Monday after the election. That was the 17th. We filed our recount on the 18th. And the deadline for filing a recount was on the 18th.
Thank you.
Or the 19th.
Yes. let me say it this way, because I want to make sure that I'm just telling you what the facts are. And I will note for the particular record here is that I'm telling you this just as myself, my understanding as one of the co-general counsels at the election division. I don't have the general authority to speak for the election division unless the co-directors give me the tell that. But the common understanding that myself, previous colleagues, my previous counterpart counsels at the election division, how we've understand the correction statute, the 312.5 14 statute, is that when referring to the deadline to file a
Correction.
recount or contest, that deadline is actually the final deadline, the deadline for county chairs to file the recount or contest. While Mr. Fogg is correct that candidates, their deadline is first. They have until, in this case, it was noon, 14 days after the election. Under statute, county chairs, in the case of state legislative recounts, have the ability to come in and file a petition for contest or recount on behalf of their party's candidates by noon 17 days after the election. And that is the date that I understand that 312.5 14 statute to follow. That is the actual final deadline that a petition for recount or contest has been filed. So I'm just stating that as just our understanding, or at least my understanding as an employee of the election division, as one of the councils there on doing those things.
But
I think that's everything that I put into the record because I don't want to be
But you
crossing over
acknowledge
into
the problem that creates is that somebody might have the election results changed after the deadline for filing for a recount. And that's intolerable, number one. And number two, this commission issued an impoundment order. It exercised its jurisdiction. There's no jurisdiction at that point to change the results. And it doesn't mean that the recount commission can't hear it, because they can hear it. And resolve whether the ballot is valid, but it becomes then the responsibility of the respondent to make that case that the ballot should be counted, is our position.
Okay, with that, then.
So are we still, I mean,
Yeah,
do I get a chance to speak?
I know,
Are we still clarifying what's going on? Because there's a lot of stuff.
Yeah, so I take it from, so obviously I've issued orders, right, that set this for hearing, that set this particular issue for hearing. It sounds like candidate Copenhaver's counsel wants to proceed with a hearing on this particular issue. I guess since we're all here and we're ready to go, I would probably make a recommendation to the commission, let's just proceed forward. And then I might ask counselor to provide towards the end of his comments, maybe what specific relief he is seeking from this commission, or that they want in their motion to ask for, and then we'll go through with the response after that, if that works for the commission.
As opposed to waiting until the disputed ballot is in front of us.
That's my understanding. Yes, instead of waiting, or possibly waiting to hear further argument on the same issue at a different time, whatever the commission wants to do.
I think we'll argue it both times.
I have a feeling.
So I don't know why that doesn't move towards waiting until the disputed ballot's on the table.
I would agree with that.
And so if that were the case, then the commission wanted to make a motion to hold this in abeyance or continuance until and let this, because again, I think it probably pointed out this particular ballot is the sole exhibit in Park County. So we know it, I would argue the same thing.
Mr. Chairman, I would move that we hold this motion until the disputed ballots are before us at our next meeting.
Do I have a second?
I would second that, yes.
All in favor, say aye. Aye.
Aye.
Opposed? The ayes have it.
All right, so we'll show that Copenhaver's objection to the untimely and unauthorized alteration of certified election results and request for emergency provisional relief from the Indiana Recount Commission has been continued to a later date by a vote of 3 in favor, 0 opposed. Next, commissioners, our second to last motion here is candidate Copenhaver's request to access save data. Candidate Copenhaver has asked this commission to issue an order or a request to the Secretary of State's office to access SAVE data, which stands for Systematic Alien Verification for Entitlements Data. This has been opposed by Senator Deary's counsel. And with that, I'll turn it over to candidate Copenhaver's counsel for 5 minutes of comment, 5 minutes of response, and 2 minutes of rebuttal. Thank you.
So the commission, you've been very patient. I'm going to try to not use my whole 5 minutes on this. Very much appreciate the chairman and Secretary of State Morales, you're procuring the SAVE data from the federal government. I think that's very important for the state and for the integrity of elections in the state. I want to compliment you for that. I also just will reference back to the free and equal elections clause that I think creates a premise that every reasonable step should be taken to ensure that voters are not disenfranchised. And so in one of the closest elections in Indiana history, I think there's a particularly good opportunity for the commission to take advantage of the work that the chairman, our Secretary of State has done to obtain this database. And we're asking that it be provided, the data that's related to Senate District 23 be provided to both parties. And so that we can check that against the poll lists that we have already received as a part of this proceeding. And just confirm whether there are any issues with other ineligible individuals voting in the election. I think it's particularly appropriate in one of the closest elections in Indiana history. The respondent in their motion said that that this is somehow an expansion of the commission's jurisdiction. And I would just remind the commission of its authority under 312.10.5(a)(6) to exercise any under this article. And the functions are to have an accurate recount, make sure that only valid votes are counted. And we think that this request is consistent with that for both parties to have access to this information. Thank you.
Attorney DeWester.
Thank you. As I stated in my response, the commission has zero authority to authorize this, zero in statute. Nothing in statute gives this commission any ability to order this select district, it's an equal protection issue as well, to run through a federal database that the Secretary of State's entered into an MOA, memorandum of agreement with, MOA, I didn't know that, and it outlines what it can be used for. It doesn't say that it can be used retroactively on the back end to see if people are registered to vote inappropriately. And then what do you do? What's the remedy? If people aren't, and I believe the Secretary of State has done a pretty good job in using that information on the front end for voter registration, not on the back end. It's unheard of, and the General Assembly did pass some SAVE data statutes regarding the use of SAVE data and regarding what our state's doing going forward. They certainly, if they wanted to, they could have put it in the Recount Commission could use it on the back end, but it's for voter registration purposes. So it's a front end issue. And the MOA doesn't allow just unfettered use of Department of Homeland Security information for any time the state of Indiana wants it for a recount to try and I guess disenfranchise people. We think, and the information contained in that system may not be timely because they could have been registered to vote or could not have been registered to vote or have the ability to be registered to vote, but the system is different. I mean, there's a timing issue getting data from them, but you guys have no, with all due respect, you have no authority under statute to authorize the use of any of that stuff. The use of it is included in the MOA that I included with my response, which is for specific reasons for the use of the Indiana Secretary of State's office regarding voter registration and issues.
Thank you. Attorney.
I think I already anticipated her argument, which was that you didn't have authority to use this information. I don't think that that's right. I think that you have power necessary to perform your functions. and a request for that information, and providing it falls within that power. Thank you.
Questions from the commissioners?
Mr. Chairman, does anyone have any reasonable basis for suspicion that there are illegal voters other than what you have alleged? Since this is a fishing expedition for alien voters, is there any reason to believe there are any? Or is this merely a fishing expedition?
Again, in one of the closest elections in Indiana history, making sure that only legal votes count is important and significant. I don't think it's a fishing expedition. I don't think when Secretary of State got that information that was a fishing expedition. What the reason that database is important is that there are a lot of individuals on the voter rolls in not just Indiana, but many states around the country that are not legal voters. And so that database has only been around and accessible to the state for a short amount of time. So in terms of trying to make this the safest, securest election possible, and in a race this close, trying to make sure that that only legal votes are counted, I think this makes sense. I wouldn't characterize voter integrity efforts as a fishing expedition. One doesn't have to know that fraud occurred in order to try to prevent fraud from occurring.
Well, there is zero proof of any kind of voter fraud or illegal voting. And let's just jump to the conclusion. What if people were registered that maybe were not citizens? Where do we find their votes? Can someone point them out?
Yeah.
What do we do with it? You can't. This data, which is currently being litigated in 2 federal courts in 2 separate jurisdictions for the use of it, they've got conflicting motions going both ways, which I referenced in my response. It's not even sure that we can use it going forward. I don't know. Let the courts figure that out. But there is nothing in statute. In recounts in contests are purely 100% statutory procedures. There is no statute authorizing this commission to retroactively go back and check this just for this district or anybody on the backside of things.
Thank you. Account Director.
Yes, thank you, Mr. Secretary. Again, this is a request from candidate Copenhaver. She is requesting to access the saved data from the Secretary of State's office. And the motion is, if you were to vote in favor of the motion, it is to issue that request to the Secretary of State's office for the saved data. To deny the motion is to not permit the parties to access the saved data.
I'll make a motion to not allow the access of the database.
Second.
All in favor, say aye.
Aye.
Aye. Opposed? The ayes have it.
Well, so for the record, the candidate Copenhaver's request to access the saved data is denied with a vote of 3 in favor of denial and 0 opposed. Commissioners, the last order of business on the motions that are pending before you are next is the candidate Copenhaver's motion to subpoena voters for depositions that was filed back with her petition back on May 18th of 2026, subsequently filed a motion to modify or to withhold 3 of those requests. So in total, candidate Copenhaver is asking for this commission to issue subpoenas to 11 different individuals whose names are not publicly known, but may be known to this commission, to subpoena those voters. And with that, I suspect that we may have lengthy argument on this. I would maybe request that the parties try to their best to not cover any ground that's already been chartered. So with that, I may suspect that maybe one of the parties may ask for additional time if they may ask that of the commission at that time.
Yeah, I guess preemptively, I'd like to offer 15 minutes per side.
Okay.
I'll second that.
And then
Yeah.
2 minutes of rebuttal to each side.
I think 15 minutes and 2 minutes rebuttal.
Okay.
Both parties agree with that.
Yeah, and
We can proceed.
We have a motion. Yeah,
We have a motion.
Yep.
Second.
in a second.
All in favor, say aye.
Aye. And then Matt, I'll make a statement ahead of time. I'm speaking for myself, and I hope I can speak for my colleagues here. Speaking for myself, I've read everything that's in it.
Great.
So for the benefit of the litigators, just please know that that's the starting point. And then for people who are unfamiliar with this process, who may be watching at home, significant pleadings have been given to us by both sides. So.
yeah. I appreciate that. And I thank the commission. Am I free to
Yeah, you're-
be in? Okay. And Mr. Muller, I think that point is important. We've been here for quite some time. And many of these issues, I think we kind of addressed with the very first issue that we hit with the election contest. I almost think that issue, that decision somewhat controls this decision about subpoenaing voters, because that is, after all, the basis for the election contest itself. And as we made clear. So I will not go back over the references to the free and equal elections clause that I think is an important interpretive aspect of what the commission needs to do in terms of exercising its statutory powers. But I do want to provide some more specifics related to the particular voters, and also to hit a little bit the privacy issue that has been raised. And so to do that, I've obviously we showed you the cases where under the free and equal elections clause, cases where the Indiana Supreme Court has said that voters can be questioned about their ballot. If it's an illegal ballot, they can be questioned about who they voted for. That is a consistent principle across many states. And we, as Mr. Mullen, you recognized, we briefed that and we cited those cases. So let's take it to the Indiana statutes and just refresh that 31016, which is on the screen, refers to eligible voters. Those are only the only voters that can vote. And those are those voters who are affirming how they voted in the last general election, that they voted for a majority of the regular nominees, in this case, of the Republican Party, holding the primary election. And only if the voter did not vote in the last general election, then does it really become a question to inquire further regarding their intent to vote in the future. I will show you a chart that reflects that every one of these voters that we're seeking to depose was a voter in the general election in 2024. So the key question that we'll be asking every one of these voters is, did you vote for majority Republicans, Democrats, or well, really, did you vote for a majority of Republicans? And that's the key question that determines their eligibility to vote in the Republican primary. It's not difficult, and it's something that's a requirement of law, and they should expect that when they go out, and I'm going to show you some of their statements in just a second, when they go out and say, we're not Republicans. We took this ballot to defeat one of the Republican candidates in the primary because we didn't want the other candidate to be successful. That's not there's not the freedom under state law to do that. That statute says you're not free to do that. Now, they may be misinformed, right? They may not have intended to violate the law. That doesn't change the impact on the integrity of the election. If they're not entitled to vote and they're voting in order to influence a party election, primary election that they're not entitled to vote in, they shouldn't have cast that ballot. So that's why we should be able to ask them about that information. Why are we subpoenaing them rather than just subpoenaing them to the final hearing? It's to save your time in part, because otherwise it might be a fairly unwieldy process if we have to subpoena each one of these voters in here for the final hearing. Instead, we think it's more reasonable, hopefully, after we see what their statements are on the record with those depositions, we can present it to you in writing. That's what I'm hopeful will happen. When two attorneys get together, they can usually agree on a way to submit things in writing. Otherwise, we have to bring in and try and ask for subpoenas for those individuals to come in here, making that final hearing a much more lengthy process. And then I'll just refer back to this partisan challenge statute, which is just another statute that shows that even if they don't realize it themselves, when an individual votes in an election, they are by law subject to having to provide an affirmation or an affidavit about how they voted in the past. That's exactly what this statute says. So how can we not be able to depose somebody and ask them a question about the very things the statute says can be required of them? And that's why we say that they have waived any right to privacy. Now, so those statutes create that waiver argument, and the cases support it, including the Kelso case, and lengthy discussion in our brief about how the Indiana Supreme Court said that when somebody participates in a partisan primary, in that case it was the Republican primary, they are affirming who they voted for in the past, and they can be asked about whether they are truly have voted that way in the past. Now, where there is evidence of illegal voting, a number of other Indiana cases, all cited in our brief, Pedrigo versus Grimes, McWhorter versus State, Wheat versus Ragsdale, all say you can go farther. You can ask who they voted for, not just how they voted in the past election, but you can ask who they voted for in this election, because that's how you find out whether the vote was illegal, and that's how you exclude it from the recount. And so that's what should happen here if the constitutional requirements are followed by this commission. And it turns out that these voters acknowledge that they were not legal voters. They can be asked then who they voted for, and at that point, that person's vote can be removed from the tally. There are numerous other cases in our brief at pages 20 through 23 from other states that reach that same conclusion. Kentucky, Texas, North Dakota, California, many, Arkansas, many cases. Okay, so here are some of the things that these individuals said. And this is in response to an inquiry by a reporter on a website to respond to him and in public if they crossover voted. In other words, and he described it, if you're really a Democrat, but you voted in the Republican primary, I want to hear about it. And so voter A, and again, we're not trying to make an example of these people. That's why we're using these fictitious names. We have their names, you have their names, you have their addresses. But we're not trying to bring undue attention on them, but they are real people. And this real person said, I don't want to be in a story, but I and some friends I've talked to did it, meaning they were Democrats that are voting in a Republican primary to support Deary against the MAGA challenger for voting against redistricting. Will I vote for him in the general? No. The next voter says, yes, I did cross over. I crossed over and voted for Deary. The next voter said, I voted in a Republican primary for the first time in my life. I left my entire ballot blank except for Spencer Deary. I just felt like my vote would be better spent there and that I could trust the other Democrats around me to make a good choice in the primary. Is that what the statute allows? Is that how we make sure that either the Democrat Party or the Republican Party or any other party has their best qualified candidates to run in the general election? That we're going to allow people to come across party lines and influence? I know that people do that, but the law says that you can't do that. So we need to uphold the law and protect the Republican voters in Senate District 23. This next voter says they vote in Republican primaries, quote, not because I'm even close to being a Republican, but because I want to vote for the best of the worst. And they said they voted for Deary, quote, but absolutely no way in the midterms. This is the attempt to influence the candidate of the Republican Party that the law says you cannot do. And that's why we're asking for these subpoenas. Next person said, I did the same thing. Response, my daughter and wife and I all did the same thing. And so it goes on. One of these what we call voter L is a Democrat office holder in Fountain County. They currently hold an office in Fountain County. And maybe they are ignorant of the law, but an office holder for the Democrat Party voted and acknowledged on publicly that they voted in the Senate District 23 primary, and they on social media told the Democrat candidate, I did that, but you got my vote in November. Is that how our primaries should be run in Indiana? Is that legal voting, that a Democrat office holder can kind of vote in the Republican primary to try to make sure that the worst candidate wins? Is that what this is about? Allowing people to vote in a Republican primary so that the worst candidate, the non-Republican candidate, the choice of people that are not Republicans wins. I thought Republicans primary was about the Republican candidate who was preferred by the majority of the Republicans. That's what the statutes say. And then the last person, in response to this about, did you cross over vote? He just said, meaning Deary, got my vote and I'm liberal as hell. So there is a strong basis to question each of these people. And it's supported by their voting history. Every one of these individuals has previously voted in the Democrat primary. Many of them, almost every election, they vote in the Democrat primary. And that's what their official election records show. These are not Republican voters. We have strong evidence that shows that they're not Republican voters, and every one of them voted in the 24 general. And so they have to answer yes or no. Did you vote for Republicans in the 24 general? And if they did, if they didn't, I'm sorry, then they weren't entitled to vote in the primary, and we're entitled then to ask them, who do they vote for? So That's that's the basis of our request.
1 minute.
I apologize. I told you I was gonna. I'll just stop here. But I do think that you kind of reached this issue already with the first decision. This is the basis for both our contest and our as a primary focus in our recount. And I'll sit down. Thank you.
May I ask a question, not against time?
Yes.
What would your response be to those people who say it is beneficial to the Republican Party to get new voters?
Then, of course, it's beneficial to both parties to get new voters. But the way to do it is not to have people vote in a primary that by law is only for Republicans who qualify by law by very, very specific. Did you vote for a majority of candidates in the prior election? There's all kinds of ways that the parties should exercise voter outreach, but we can't justify breaking the law because we think that'll bring more people into the party. It's really not about bringing people into the party. It's about what happened in this election. Was the law followed? Were these votes legal votes?
So in other words, are you saying that bringing new people in the party is something that should be done in the general election? If people are motivated to vote for the party's nominee?
Absolutely. I mean, if the system is set up, the primaries are set up to have the best, the person that's the best candidate selected by Republicans, and hopefully that means they're going to be able to bring in a lot of votes. Everybody should be able to vote for who they decide is the best candidate in the general. No dispute about that. It's about whether you can kind of under the radar try to illicitly undermine the other party's candidate, which was really the effort.
Or manipulate an outcome?
Right.
Yeah.
Right. And we shouldn't be allowed to violate Indiana law to manipulate the outcome of an election.
And I didn't see this addressed anywhere, just in the briefings. And sorry, I don't know if there's a time issue here, but is there a penalty associated with someone who violates this accidentally or unknowingly? To your knowledge, it's not an issue for this motion, but just out of curiosity.
You mean like, will they be prosecuted?
Anything.
I mean, I wouldn't opine on that. I doubt that any prosecutor would pursue this, but I have a feeling that this case is going to cause renewed focus on these issues in Indiana election law. And hopefully it'll be for the good, because people will start recognizing that we need to follow the law and what the law is. But I haven't researched whether there would be kind of some sort of sanction. And I doubt that any prosecutor would pursue that.
Commissioner Baker.
Chairman, if you don't mind. How do you square the closed primary statute with free association?
It protects free association. It protects the freedom of Republicans to associate together. One cannot impose themselves on a political organization. One cannot impose themselves on a religious organization. One can't impose themselves on a social organization like a country club if you don't meet the membership requirements. One cannot impose themselves on the American Legion or the veterans of foreign wars if you haven't fought in a foreign war. We protect association by having rules about what organizations stand for and who can be members. And that's good for our country. That's good for our society. And that's how we celebrate true diversity and true diversity of thought is by having organizations that allow us to associate with people that have the same ideas and pursue those things and have a synergy together. Not that we have no standards, no criteria, no ability to associate, which not enforcing the law would do here. It would destroy freedom of association.
Okay, I think in Morales v. Rust, Justice Massa would have agreed with you on leaders of parties or candidates, but distinguishes the free association rights of voters separate from those types of free association, as you said, of limitation.
And that's exactly what we're arguing for here. I mean, the candidates, we're talking about the selection of candidates to be the nominee for the party. It's important to protect the selection of candidates aspect and make sure that the candidates are selected by Republicans. In the general election, everybody can vote for that person. And that's the distinction and the difference, Mr. Claytor. And I think there's a very long history in Indiana of strengthening parties by allowing the parties to figure out how they accept members, and here both parties agree, and it's in the Indiana code, it's in the law, and we simply need to respect the law until it changes.
Thank you. Any other questions? Attorney DeWester, floor is yours.
Thank you. I think Mr. Bach hit it on the head as he alludes to changes in code. What they're arguing and what his client wants is she's dog whistling the General Assembly about closed primaries, and everybody that's been talking about closing the primary and people that are running on platforms of closing the primary. There are statutes in place that protect the parties and voters and how they vote. What they fail to mention on this little thing here is that in the off years that aren't listed there, most of those people voted Republican. So this wasn't an issue of where it was just hardcore Dems voting. They were mixed backgrounds. But again, we don't know who these people are because it's never been proven outside of comments on social media, right? So they've taken the liberty of invading their personal voting background and putting them, in petitions to the commission that we've all seen, based on mere comments online. So let's talk about the Kelso case that they keep mentioning. That is indeed an Indiana case from 1916, right? And it opines about the 1915, it interprets the Indiana primary election law because the act was passed, right, to create primaries. And it was disputed. That's why the court at the time said, yes, there can be party primaries. That's fine. There's not an issue. Yes, the question was not, can someone vote which way, or you can question voters about ballots and you must tell us who you're voting for. The issue was, is this legitimate, the primary act itself, and can they impede voters' right, ultimately, the fundamental right to vote? And the answer was yes. They could put restrictions on because the parties at the time had the ballot access, right? They switched it to the government dealing with ballots, and thus became the Secretary of State's office and became clerks and all kinds of stuff handling all of this for Indiana instead of the partisan parties, right? So we aren't arguing that there should be barriers in a primary at all. In fact, we've not even challenged that. What we've said is they're not following the law. And instead of following the law and challenging people what's appropriate under the code, they want to now challenge them on the back end because they didn't do anything on the front end. And so now they want to say, wait a minute, someone made a comment, someone told somebody that they voted for or whatever. A lot of those comments are innocuous. Yeah, I voted for them. Well, how did you vote? They didn't say, I voted in the general. I'm intentionally violating statute 3-8-. That's not what happened, right? These are voters that are rural individuals who probably have never been in a courtroom, never subjected to a deposition, now being questioned by one of the most personal, private decisions that you can make in voting because they think it's the same person, they think they violated, they have no idea how they voted, if they voted in the Senate race itself. But yes, we need to bring them in, compel them, have the Indiana State Police go out to their door because that's who serves the subpoenas for a recount commission, and drag them into a deposition. That makes sense, right? That makes no sense whatsoever. It's actually a disgusting thing that someone wants to bring in the general public. They're non-parties to this case. They filed the contest and recount, not the individuals that are voting. It wasn't until several days later they noticed comments and thought, aha, we could use this as part of our argument. Let's bring in the totally innocent Hoosier voters to make our case for us. And let's subject them to depositions and tell us how you vote. When you voted, did you vote the general? Are you going to vote the next general? Who did you vote for? Right. So in the cases that they talk about, you can be compelled to talk about how you voted. It doesn't say that you have to tell who you voted for. How you voted is a party thing, right? It's mostly based upon criminal accusations, people that have knowingly in pay past. How did you vote? Because we know that you signed these fraudulent absentee ballots. We know that you registered illegal people to vote. We know that you did X, Y, and Z. Yes, that's a criminal matter. Of course you can compel someone to tell you how they voted because they're facing criminal charges or they're, a lot bigger things going on as opposed to we want to talk to them because we think this is the basis for how I win an election, right? Also, I'll revert back to First Amendment rights. People can say whatever they want. That doesn't mean they're held to account to subpoenas, especially when it comes to the fundamental right to vote in an election because of something they said after the fact. How many stupid things has anybody seen on social media where people glom on like, oh yeah, I did too. Funny, they haven't mentioned the 3 individuals that they had initially in their petition that they realized that the same people that said, oh, I did too, I voted, I crossed over for him. Oh, whoops, I don't live in the district. So then therefore I was lying, right? That's the only conclusion that can be drawn. They posted something on social media saying, I voted for Senator Deary. Oh, I don't live in the district. Therefore, I didn't. I was just kind of joining the crowd, joining the hullabaloo because I want to feel like I'm part of something. I want the attention and social media. And most voters, quite frankly, don't understand you must vote one way in order to pull a primary. I know many people that have crossed over both sides of the aisle, right? I, as a younger voter, I changed my voter persuasion. I pulled a primary ballot for the Republicans many moons ago, right? People switch parties. There's nothing illegal about these ballots. They're not invalid. They are not illegal. There aren't illegal votes cast. There is nothing that they could be prosecuted for. If you look at voter fraud, it doesn't include voting in a primary. There is no ramification. However, they are an issue in search of an argument, and this is the vessel for that argument, right? So we can dog whistle everyone about how we must change our laws. I've done enough of these to understand how good our election laws are and how secure they are and how good our clerks do and everyone that is working polls and whatnot. To have that put in question because of some random people posting on social media about how they may or may not have voted when half of their voting history is not even reflected here because there were Republican primaries that they pulled in. I saw a lot of the same data that you did. So it's not genuine to say this, but to subject an innocent person that has nothing to do with private litigation only for the very much of her benefit to win an election is disgusting. So we're just going to pull in random people that we've not verified at all. They can say they're verified. And what they mean by verification is the names match. Okay, well, how do you know that person on social media is that person? How do you know that? How do you know that they were the ones posting that at the moment? You don't. You have no idea. And it doesn't matter. We shouldn't let red herrings like this hijack our elections. It's just dishonest. It is disrespectful to the entire election integrity process. Make your argument to the General Assembly, but there's no way that the General Assembly ever thought, I'm going to give the Recount Commission the power and authority to do anything else general or issue subpoenas and have it mean general voters. When will this stop? This is unprecedented, and it will set the precedent for future elections to drag in innocent people that have not been verified. No one knows who they are. And that wouldn't even begin to make a hurdle on any kind of civil or criminal or any kind of action. This is voting. Voting is up here as opposed to a civil action. We should be better. We should have information before we start telling people we're going to pull them in. This is not government intrusion into a private personal life. You issuing subpoenas to civilian, non-candidate, non-political party people to come in and compel them to talk about how they voted, which we've had ballot secrecy laws here since the 1800s. Right? That's been a precedent. That's been the whole policy around Indiana ballots. When we switched to the Australian ballot type, right? That whole thing is ballot secrecy. 311.13.8 talks about secret ballots, talks about if there's not enough space even at the polling sites or something that you can't see, you must make plenty of space so people have secrecy and privacy during voting. Not one of these people signed an affidavit or was challenged at a polling site. How do I know that? Because I was at the recount in 6 different counties and there was no documentation saying that they were challenged or signed an affidavit, therefore waiving any of their right to privacy. So we are now grasping in a fishing expedition at the hopes of having some basis in any kind of, I guess, rational basis for the verified petition for the contest. However, there is none. Because these are just innocent people that we don't even know who they are, but yet we're trying to make them who we say they are so that we have a challenge and then we can win an election based on this. I mean, I guess it did surprise me to receive, a text from someone saying, hey, well, someone posted this. Maybe we should have this held personally against Ms. Copenhaver. Ms. Copenhaver personally thanked a good friend of mine who is a staunch Democrat for pulling a Republican ballot in this exact primary. He quoted her saying, thank you, because I need all the help I can get. Anyone that voted for that. Yeah. So should we track down that person and maybe subpoena them to a deposition and say, hey, did that really happen? No, that's ridiculous. We're better than that. We don't do that kind of stuff. That's a waste of our time, a waste of taxpayer money. We have now spent many days and hours and staff and resources for this, just for this. There's no basis in it, but we're going to spin up all of this stuff. There are issues at the General Assembly. They can go do it. Everybody's talking about, closed primaries. That's going to be, go knock your socks off. Overturning an election because you think it should be done because you didn't win is not the time to campaign for closed elections. The voters have been waiting for 3 months to find out. Now we want to depose them. It's just an insult to anybody that would ever consider voting. So government intrusion by issuing subpoenas, violating First Amendment rights of individuals, violating privacy rights of voter secrecy and ballot secrecy. I can't imagine I can't imagine what will become of that. I guess there's lots of lawsuits. If you were to issue subpoenas to depose individual voters in violation of the First Amendment, that's what will happen. Or class action. I mean, I don't know what anybody expects to come of this, but people aren't just going to roll over and say, hey, come depose me and ask me how I voted because it makes you feel better at night. And censuring free speech by essentially saying you can't say anything this doesn't even sound like a country in which I live, right? It doesn't even sound like Indiana. When you talk about government's going to censure your free speech because if you say something incorrect or not liked on social media, in particular against a candidate, you're going to be drugged in for a deposition. We're going to question you about what you do, how you do it, when you do it, why you did it. We don't care about the secret ballot thing, which is going to turn people away from voting. Everyone that's watching this, the news people behind us that are carrying this, people are going to watch this and say, why would I vote? Why would I ever get involved in anything? We already have a very low voter turnout. Why would I vote if this is the nonsense that's going to occur to me? It doesn't sound like a platform I want to be associated with. We want more government involved. We want more people issuing subpoenas. We want the 40, 50 people that have been involved for the past 2 months. We want more of that. We want less free speech. It sounds like a platform from another country or a planet. I don't know, but it's not the party that I belong to, right? So it's an insult to everyone. Probably the General Assembly the most because they didn't write the statutes for recounts and contests for this reason, to abuse and harass voters because of social media posts, right? And the election code wasn't codified until 1986. So, I mean, all these cases from the 1800s and 1912s and whatnot, it's codified in 1986. And you could look and see what the intent of the General Assembly has done. It streamlined it and brought it together. So obviously no one has, thought that there'd be a Facebook or a Twitter or whatever with their changing code. I'm guessing they will now. I'm guessing some tweaks will be made. Every time I do it in Recount, I'm assuming tweaks are being made by those watching what's going on to prevent this kind of stuff from happening to voters. Otherwise, why have elections? But no one's going to participate doing this to them. I certainly wouldn't. If I received a knock at my door to the state police saying, hey, you're put on notice, you need to go to a deposition. We can't be that place. So at this point, I'll stop reiterating this because I've written it in my brief and I've talked enough and I'm obviously passionate about it because it really incenses me as someone who's worked many polls, someone who's worked and helped the Republican Party do a lot of stuff in Indiana. It's disappointing to see that this is what's going on. Let the lawmakers do the law stuff. Let the election folks do the election stuff, but we shouldn't be telling a recount commission, this is what you need to do in order to get what we want the General Assembly. You're talking to the wrong folks, right? Thank you.
Thank you. Unless the commissioners have any questions to Mr. Wester, we can give 2 minutes of rebuttal.
Well, I do have a question. When you reference what are the actual mechanics when you use phrases like challenging up front? If someone should be voting in a party primary, they should have been challenged up front prior to casting their votes. Can you walk me through what is the mechanic that a candidate should be doing? Because that sounds, it sounds almost impossible with the number of voters in one candidate. And how would you know, like, the intention of the candidate, of the voter ahead of time?
Yep. So it's under 31019 about challenging a voter in a party primary that you think there's a state form that's out there that election administrators get in every county. The secretary could probably confirm that because that's what they're taught through their election training and whatnot. And individuals that know of the same party that know someone or they think someone isn't voting honestly wrong. This is what the law says. This is not what Samantha Wester says. If they don't think that they're following the party primary, they think that they're an independent or a Dem based on whatever knowledge. It's not really delineated in law. It's, I've dealt with some a few years ago. There was a hullabaloo in Southern Indiana. Someone puts yard signs out for Dem, someone is married to the Dem party chairman, but we know this person's not Republican, but they're pulling a ballot. So they tried to make them sign that form and then things kicked off. But that form is what the law prescribes, right?
And that's in advance of the vote actually being cast?
Yes. And the law intentionally states, the General Assembly intentionally carved out these types of challenges. They are not provisional. They count. As long as someone signs the affidavit, it's a form. And it's a sworn affidavit saying, because poll workers have notary power on election day working the polls. So they can sign, it's swear affirm under penalties of perjury, I notarize this. And that I either voted in the last general or I plan to vote for the majority of the parties in this upcoming general. And that's what they signed. It's a state form. It's prescribed by the state of Indiana. And that's what, they had challenge cards. In Marion County, I've always been a challenger or a watcher. They have those cards, meaning people from the same party can challenge someone standing in a polling site, watching and challenging. I know that person, they're my neighbor. And yeah, is it weird? Mm-hmm. But that's what the law prescribes. That's what should have happened. There is no 31019 2.0, do it on the back end if you didn't do it on the front end type thing, right?
And then what's your response to, I heard you use the phrase random voters are being subjected to depositions, but they're not. When we have a very small finite group of people who are being asked to be subjected to depositions. They're not random. They've put, and tell me if I'm saying this incorrectly, they have made it public in the most public way online about how they voted in their conduct on election day and their motivations. So I mean, would you agree they're not random people? I mean, these aren't random voters that we're pulling out of society. These are very identifiable voters that made their selves known.
I guess I would ask how they've been vetted then. So I got the criminal attorney and me and litigator. How do you put someone at a scene or put someone as a party to it when you don't even know who they are? When you're using a name online, you don't jump to a subpoena for a deposition, right? To compel them, especially about voter things. If this was a personal injury case, and you track down some folks, you try to find them and, talk to them or whatever, you could subpoena them. They don't have to show up, I guess, if it's a civil matter. This is about voting. Their identity is not vetted, is not known. It's what they think it is. That's it. Based on social media. If you commented on social media and then I found another Paul Mullen someplace else at Wrexham, AFC and Wales. But I mean, what if that Paul Mullen posted something online and someone said, oh my God, Paul Mullen is a bigot. That guy just posted this. That's not you.
Yeah.
How do they know who posted? Who had access to their accounts? A lot of husbands and wives share accounts, right? I mean, you don't know who posted that to say what they did, but yet we're going to pull voters in to say, was that you? How'd you do it? You wouldn't be able to do that in other litigation. It definitely shouldn't be allowed in this litigation.
But if there was a deposition in your example with me and someone, I show up to the deposition and depositions occur all over in every county, dozens of times a day in Indiana. And the first question is, was this you who posted this? And I said, I've never seen that in my life. No, it wasn't. There's nowhere else for that deposition to go. It's over for all practical purposes.
Right. And the biggest difference is this is not a civil action, right? This is a heightened scrutiny, strictly statutory creature that is not a personal injury matter, right? In that what I just said about Paul Mullen and, Wrexham, say it was a libel or slander, totally different, totally different. This is about voting, a fundamental right, and pulling people in to say, is this you? You don't have the ability to do that. I don't know what they would say or how you don't have the ability to order unknown individuals to a deposition. Nothing else has been attempted to get a hold of them, but yet we want to depose people that we don't even know for sure that's who it is. And keep kicking this can down the road because, we can wait until whenever to find out the end of an election because we think that these people might have some knowledge possibly about something. And their statements aren't criminal, aren't civil. There's no repercussions for it. So we're just going to use it here to disenfranchise thousands of people in Senate District 23.
Any other questions? 2 minutes for rebuttal.
So Ms. Wester's opinion in response to your question, Mr. Mullen, is the greater the right, the less there is opportunity to protect it. You can bring civil action and subpoena somebody for slander or for personal injury, but you can't protect the right to vote. You can't protect the right of parties to protect their primaries. That's her position. She says that there's a personal right to break the law and subvert the choice of Republican voters. That's what she said. These people had a personal right to do what they did. So now, and not only that, it's protected by the First Amendment. To break the law, violate the law, is protected by the First Amendment.
1 minute.
I mean, this is not the way that we should approach these issues. These are important. The right to vote, there's nothing more sacred. People die for that right. And protecting it is by requiring people to follow the laws. This isn't censoring free speech. People don't have, and they freely spoke and admitted they violated the law. It's simply, and she says disenfranchising the voters in Senate District 23. There's no disenfranchisement. The Republicans are disenfranchised if they're voice is not respected. She says we have no idea if they voted in the primary. That's not true. We know these people, each of these people voted in the primary.
Time.
Thank you, Attorney Bog. At this point, Recount Director Norris, anything else we may need to cover?
Mr. Secretary, the only thing I do want to point the commission's attention to is Chapter 2, Section 23, since the issue of what is the commission's role, or what is the responsibility in terms of evidence. And I just want to read this verbatim, just so that the commission has this. The commission may accept evidence in a proceeding, even if the evidence would not be admissible in a judicial proceeding under the rules of evidence. In accepting the evidence described by this section, the commission shall ensure that the commission's proceedings are conducted with the decorum required to protect the rights of the parties to the proceeding and other individuals. I just wanted to remind the commission of the discovery process, or as laid out in the guidelines that you all have adopted, that we're not necessarily required to follow the rules of evidence, but at the same time, ensuring that decorum is required to protect the rights of the parties to the proceeding and other individuals.
Thank you, Recount Director. Any other questions? Should we make a motion?
Mr. Chairman, I would move that we deny the motion to subpoena the owner's deposition.
Do we have a second? I second it. And before we vote, I would like the opportunity to explain my vote, if I may, commissioners. My first, I was exposed to my first recount when I was a young staffer back in 2004. And, here I am right now as the chairman of the Recount Commission. And it's an honor to be the 63rd Secretary of State. First and foremost, I believe that the time to challenge voters is at the polls. That's what I've been a poll worker myself. I've been doing this for a few years. But number two, actually, we could have avoided all of this if the General Assembly, I've been a big supporter, and I've been promoting close primaries for the past two sessions. The past two sessions, I think everybody can attest. I've been promoting that we pass legislation and encouraging our General Assembly to close our primaries. I am a proud Republican, and I believe that's the way to go. And I will encourage the General Assembly next session to hopefully this time pass legislation and close our primaries once and for all. Secondly, I can tell you this, that this is the right thing to do, to make sure that we reject the motion to subpoena any voters, because I don't believe that's the right thing to do. I believe everybody, has the right to go and vote, but they need to do it the right way. And the right way, again, is I encourage the General Assembly next session to close our primaries so we can avoid all of this. And that's the explanation of my vote. And I think we can, if anybody wants to explain their vote before, I'm happy to.
Mr. Chairman, I would like to explain my vote. Sorry. The recorder in each party. Yeah. Thank you, Mr. Chairman. Let me, if you wouldn't mind passing those down. I'm going to be a little wordy. It's not 50 pages, so please bear with me. In order to explain my vote, I'd like to say Indiana does not have a typical closed primary system. States with closed primary elections are typically structured So when an individual registers to vote or changes their voter registration, they designate which political party they choose to vote for. When a primary election occurs, only voters registered as Republican voters can vote in the Republican primary, and only voters registered as Democrat Party voters can vote in the Democratic Party primary. In open primary states, any voter can choose any party's ballot in the primary. Indiana has created a hybrid system that statutorily closes the primary based on political party, but does not clearly communicate that fact to potential voters. Compliance is measured by a state of mind. It is at best a backdoor closed primary, although it is described as a semi-closed primary in Hervey State, 212 Northeast 3rd, 1261, Indiana Appellate 2023, transfer denied in its note 1 at 1265. The statute Indiana Code 31016 states, a voter may vote at a primary election if the voter at the last general election voted for a majority of the regular nominees of the political party holding the primary election, or two, if the voter did not vote at the last general election, but intends to vote at the next general election for a majority of the regular nominees of the political party holding the primary election, as long as the voter was registered as a voter at the last general election or has registered since then. The enforcement mechanism for this mind-reading closed primary requirement is the challenge process in section 31019. If challenged, the voter may swear out an affidavit that generally tracks the requirements of section 6. Indiana Code 31452 provides a mechanism to submit these affidavits to the county prosecutor for potential submission to the grand jury. Indiana Code Chapter 314.2 contains the sections of the code that describe the various actions that the legislature has deemed to be vote fraud. None of those sections in that chapter describe the primary crossover voting proscribed by Indiana Code Section 31016 as being vote fraud. IC 31452, the enforcement mechanism for primary crossover voting, seems to describe a grand jury process for which there is no corresponding crime to charge, other than completion of an affidavit that may prove to be false. None of the voters under consideration were challenged, and none of them filled out such an affidavit. The statute prescribes the actions surrounding a false affidavit, not the act of voting. Petitioner in Senate District 32 Recount has requested subpoenas to question voters to determine whether they violated Indiana Code Section 31016. Petitioner had the opportunity to challenge voters during the voting process and force the affidavit process described above, but did not do so. By not using the mechanism set out in statute, petitioner has waived its only statutory opportunity to challenge the voters in question. Voters have the rights of free association and voter secrecy under the First and 14th Amendment of the Constitution of the United States and under Article 2 of the Indiana Constitution. In Morales v. Rust, 228 Northeast 3rd, 1025, Judge Massa has a good discussion of the tests that must be applied. The opinion, in discussing the rights of free association, indicates that political parties have a stronger interest when selecting party leaders and candidates in determining what individuals should be members of the party. He goes on to point out that this analysis is different when looking at candidate rights versus looking at voter rights. The level of scrutiny depends on the Anderson-Burdick test. As set out by Justice Massa in the Rust case, the balancing test from Anderson requires 3 inquiries. First, the court must, quote, consider the character and magnitude of the asserted injury to the rights protected by the First and 14th Amendments, end quote, 460 U.S. 428 at 789. Second, the court, quote, must identify and evaluate the precise interests put forth by the state as justifications for the burden imposed by the law, end quote. Third, in weighing the rights burden and the state's interests, the court, quote, also must consider the extent to which those state interests make it necessary to burden the plaintiff's rights, end quote. Morales v. Russ, 228 Northeast 3rd at 1038. It should be noted that Her v. State, 212 Northeast 3rd, 1261, did not find that the closed primary system violated Her's rights as a voter, but the case was based on Her's assertion that he should not be forced to declare a party at all in a primary to vote for the nominations of judges on a partisan basis. He asserted the right to vote for judges in both parties' primaries, not in one or the other, which he may or may not have supported as a party member. Her was challenging the existence of the primary, not which set of ballots he should have access to. The instant case is based on free association and ballot secrecy, not on whether a primary or nomination system should be partisan at all. Her's language describing the analysis process and outcome is not applicable in the instant case. The normal enforcement process for 310-16 is the challenge and affidavit process, where the petitioner did not avail themselves of the statutory process to challenge these voters, which they had every right to do. They now wish to pierce the voters' right to ballot secrecy to try to throw out these unchallenged votes. There are instances where ballot secrecy must be pierced to prove voter fraud. Petitioner cites Pedigo v. Grimes, 13 Northeast 700 Indiana 1887, and McCarter v. State, 196 Indiana 460, 148 Northeast 477, for the proposition that voters may be required to disclose how they voted. In Pedigo, there was no showing that illegal votes occurred, so the voters were not compelled to testify. In McCarter, questioned votes included ballots with distinguishing marks and a voter that voted in a precinct where he was not a resident. These matters do constitute voter fraud, not just a, quote, illegal, end quote, vote. And such testimony was allowed. Primary crossover voting is not voter fraud under Indiana law. Williams v. Stein, 38 Indiana 89, 1871, struck down a statutory provision that required the precinct inspector to number each ballot and record the number in a poll book by the name of the voter. This statute was found to violate ballot secrecy and was therefore void. The Indiana Supreme Court adopted the opinion of the lower court, which forcefully defended the voter's right to ballot secrecy. We should defend that right as well. Petitioner cites Indiana Rules of Evidence 502B as standing for the proposition that some voters have waived ballot secrecy by posting how they voted on social media or by disclosing such matter to others. It should be noted that such social media assertions may not be accurate, as evidenced by a subsequent filing by the petitioner, noting that some of the assertions did not come from actual voters in the district. The Indiana Recount Commission is an administrative body of the executive branch of Indiana government, created by the Indiana General Assembly to adjudicate election recounts and contests. The Recount Commission operates and adjudicates matters before it under its own guidelines and procedures. The Recount Commission is exempt from the provisions of Indiana Code Article 4-215, which govern agency administrative adjudications. Quite simply, the Indiana Rules of Evidence do not apply to the Indiana Recount Commission. In summary, ballot secrecy is a fundamental right of voters, subject to a strict scrutiny analysis under the Anderson-Burdick standard. To the extent that the Indiana closed primary statute can be enforced by the challenge affidavit methodology, it does not directly infringe on the voters' ballot secrecy rights. Although it may infringe on the voters' free association rights, that question is not before the commission and is a matter for the courts. In the instance case, the petitioner did not use its legal opportunity to challenge voters under the non-infringing method provided by statute. If the legislature passed a statute that required prior party registration for a closed primary, as many states have, the state interest would be served without violating ballot secrecy. And since registrations can be amended, it would not violate free association rights. The legislature could have created a non-infringing framework for its semi-closed primary system, but it chose not to do so. The legislature could have defined a crossover voter's action as a crime, but it chose not to do so. Based on this analysis, the requested subpoenas should not issue. Thank you, Mr. Chairman.
Thank you, Commissioner Cater. Commissioner Mullen?
Very briefly, I'd like to thank, before we vote, both lawyers for both sides, just a really impressive legal briefing in advance that spelled out all the issues that we heard today. And in this very narrow factual situation, I find petitioner's motion to subpoena these voters, again, under this factual situation that's been presented to us, well taken. And we'll be voting in accordance with that. And I have no comment on what the legislature should do in the future. That's up to that body, how they conduct them or how they decide to move forward. I have no comment on that. My decision and my vote is based on what the statute is today. And it's my belief that petitioner's motion to subpoena should be viewed favorably by this body.
Thank you, Commissioner Mullen. Do we have a motion?
I believe we have a motion and a second.
I was in second. Well, all in favor to
deny.
Vote aye.
Aye.
Aye. All opposed?
Nay.
The ayes have it. 2-1.
Thank you. Let the record reflect that candidate Copenhaver's motion to subpoena voters for depositions has been denied with a vote of 2 in favor of denial, 1 opposed to denial. With that, Mr. Secretary, that concludes all of the, there are other related motions to the subpoena voters for deposition. However, those are now moot because of the commission's ruling. The other matters to discuss, whether any of the parties have any logistical questions for the commission or any updates, I have none at this time. The only other matter of business, Mr. Secretary, is to continue with the count. Now that we have direction on the discovery motions, I have proposed and have checked with the representatives. I believe August 18th is a good date for everyone to reconvene with since the commission put the rest of the count into abeyance earlier in the commission hearing. We can continue on August 18th if everyone's still available. And if that still works for everyone, and I will issue an order to that effect.
Evan, can I make one oral motion?
Sure.
Okay.
Or I guess I should leave it up to the commission if they'll accept your oral motion. I apologize.
Can I make
You
an
may.
oral motion?
You
Okay.
may.
Mr. Chairman and members of the commission, the petitioner requests subpoenas for each of the 11 individuals to attend the hearing of the final recount and contest hearing in this matter. Thank you.
Thank you, Attorney. What would be
Did
the,
we have a reply to
I would
the oral motion?
I would probably let them respond to that motion.
I guess I'm confused. So we want to force them to come watch this for a few hours on the 18th. Are you trying to compel them to testify? What is the ask?
To compel them to come and testify.
No.
Is there a request for a subpoena, a testimonial subpoena at the final hearing?
Obviously, that's in the same vein as, let's call all these folks in from an hour and a half, 2 hours away, drag them down to this private litigation and force them to testify. Absolutely not.
Recount Director.
Yeah. Obviously, this is an oral motion that I did not necessarily have anything prepared for at this time. However, again, I believe the commission under Chapter 2, Section 23 has broad discretion to permit evidence in a proceeding. You don't necessarily have to follow the rules of evidence, but while also requiring decorum to protect the rights of the parties to the proceeding and other individuals. At this point, open it up to the commission and legal counsel, perhaps, if they have any recommendations on how to proceed.
And that evidence can be in the form of testimony?
Yes.
Mr. Chairman, I would move that we deny the motion.
Councils. Matthew.
Well, the motion, well, you need a second after this one, but on the question there, I mean, if you order a subpoena, that would have to go out, they would have to order them down here. If they refuse to comply, I have an open question about how that would actually be enforced. You'd have to get one of the parties, I'm going to assume, is going to have to walk into court to get that done, for which then, if they're not here on the 18th, what are we going to continue this? I will tell you, and I believe that the recount director has made this clear to the parties in one of his communications beforehand. The election division is certifying names for candidates on the general election ballot on Friday, August 21 by noon as required by statute. That goes hand in hand with the other statutory requirement that the election results that were certified to the election division back in May had to be officially canvassed by the state and then certified by the Secretary of State. That has to happen all at the same time. So I would just say, in your consideration, there are some deadlines that are coming up. Those deadlines have to be observed. If not, then the counties cannot prepare for the general election, and we put every single precinct, every single voter in this state who's going to participate in that general election in an awkward position of, are they going to have a ballot to be ready to be voted on? Because, Mr. Secretary, as you are very much aware, there is a stringent calendar on preparing absentee ballots, on preparing the general election ballots, and voting is going to start very soon in September.
Thanks, Matthew. Sprint.
Nothing to add. I think there's a motion on the table and it just needs a second.
Mr. Chairman, in addition, we'd make a second motion, which would be to hold the final recount hearing in Tippecanoe County, which is our right under the statute, which would facilitate the enforcement of those subpoenas for 9 of the 11 individuals who reside in Tippecanoe County.
Thank you.
Can I respond? I don't care if we have it in Greenwood, although it's not part of the district. The issue is voter testimony and compelling them to testify. For all of the reasons we all just walked through and it was denied is the exact same reason. I don't care if it's in Tippecanoe County, I don't care where it is. Voters should not be compelled to testify about who they voted for, how they voted, what they did based on something on social media. For all the reasons that Commissioner Claytor went through. The legal, a lot of that was in my response as well. I mean, to their request, it should be denied.
Can we back up very quickly? So we have a motion on the table to deny the request for oral testimony.
We have a motion made. We don't have a second.
We do not have a second. Okay, so the motion's been made, but we don't have a second at this point. Just make sure that we keep it within the confines of everything that we're here to talk about. So there has not been a second yet, but there is a motion that has been made.
So you made a motion, right? Right.
Deny the first oral motion.
I'll second it. Those in favor, put aye. Aye. Those opposed?
Nay.
The ayes have it.
I will show then that candidate Copenhaver's oral motion for issuance of subpoenas to the 11 individual voters has been denied by a vote of 2 in favor of denial one opposed. Second, now we have another motion to conduct the hearing in Tippecanoe County. The only I do not disagree with Councilor Bach's statement that it must occur in the county. However, it is my reading of Section 20B3 that the commission can dictate which county in which to start in. So while the parties do have the right for us to go back to Tippecanoe County, it's up to the commission to determine whether or not they want to start in Warren County or Tippecanoe County or so on and so forth. So with that being said, I don't think that the commission's necessarily, they can take the request to have the hearings in Tippecanoe County. But again, it's ultimately up to the commission on the order of which that'll proceed.
I'm open to whatever it may be. Can we get to you at a later date, or do we have to make that decision right now?
I would, I mean, it makes sense instead of wasting even more taxpayer time and money driving an hour and a half to Tippecanoe County just one way, because all of these folks have to go up there. And we've already spent many hours together. If we just have it here in central Indiana, where it was intended to be, where we agreed to have this, that makes sense. Everyone is here as opposed to driving and taking all the stuff with us and setting up like we did for 6 different counties.
And I'll just make, in terms of agreed, we were very explicit, and our agreement was for this hearing only. And the statute does require the proceedings to take place in the counties in the district.
I would tend to agree with Mr. Box. It does require us to go in the counties. However, we can dictate. Now, if the parties were to agree that we didn't have to go to all 6 counties and we could just go to Tippecanoe County, for example, that would help to expedite some efficiencies in the process. I can understand not having the recount here in Marion County, but maybe if we could reach some agreement on to have the hearings all in Tippecanoe.
Well, yeah. I mean, I'm not going to make an agreement now, but I'm certainly willing to talk with you, just like we've worked with you throughout these proceedings.
Okay.
But I wanted to make sure that our current preference was recorded.
I would recommend, if it's okay with the commission, that I coordinate with the parties and determine where and when we will start in Tippecanoe County while following, obviously, the guidelines to make sure that we can just get this done efficiently.
Would I agree with that?
Yeah, Mr. Chairman, we should go to Tippecanoe County.
So is he withdrawing his motion, or what are we doing with his own?
No, I didn't withdraw the motion. My understanding of what's just transpired is that our motion's out there and that we'll discuss it among council. What would be the most efficient way to proceed? And obviously the commission can hold their hearing. If they want to hold it in the district, they can hold it in the district. We can't do anything about that. So
That's okay. You can go through.
Yeah.
You can work with both parties.
Yes. Yeah. I would, if you want to make a motion that we start.
That we authorize the recount director to work out location with the parties, and I'll just leave it at that.
Do we have a second to give Mr. Norris the authority to work with both parties? Okay, all in favor, say aye.
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 Opposed? Well, the ayes have it.
Thank you, Mr. Secretary. With that, with showing, again, tentatively, we're going to hold August 18th and August 20th, 2026 for future hearings in this matter, holding 2 days. Location obviously to be determined at this point. I'll work with the parties on that in compliance with the guidelines. And at that time, Mr. Secretary, that's all that I have on our agenda for today.
Thank you.
It's the 20th?
Sorry, August 18th and August 20th. Yes.
You said the 26th. I just want to.
Sorry. August 18th and August 20th.
Well, is that going to work if we are in 6 counties? I mean, I don't know if it would expand beyond 2 days.
We're good. We're going to make it work. We'll figure it out.
Well, thank you, Recount Director. May I have a motion to conclude and adjourn the Senate District 23 recount and contest proceedings? May I have a second?
Second.
Is there any discussion? All those in favor of adjourning the Senate District 23 recount proceedings, say aye.
Aye.
Aye. Any opposed? The ayes have it. We are adjourned until our next hearing.